Okay, I'm going to call the Lancaster Board of Appeals meeting of September 19th to order at 7:03 p.m. Start with a roll call attendance. Dennis Hubbard. Here. Eric Jacobowitz.
Yep.
Frank Sullivan.
Here.
Rick is here. No, Rob is traveling. Who else is missing?
Mike.
Oh, Mike. Yeah. Is Mike? See him there. But he can't have this anyway, so he's probably. Okay. First item on the agenda is to approve minutes. We're going to table that until our next meeting. We'll go right into the public hearing continuation for 13 Neck Road. We went to CMR 56052 in Mass General Law, Chapter 40B, the Lancaster Board of Appeals, to hold a public hearing on Thursday, December 13, 2023 at 7 p.m. via Zoom and at the National Meeting Room, Lancaster Town Hall, second floor, 701 Main Street, Lancaster. To hear and act upon the following matter: a petition by Neck Road LLC, 66 West Street, Suite 1F, Lumberton, Mass, for the following: a comprehensive permit for the construction of 11 units of housing, including 3 affordable units, 0.56 acres. Property is located on Neck Road and Centerbridge Road in Lancaster, and is identified on the assessment map 34, parcel 42. Copy of the application and accompanying documents are on file in the Office of Community Development and Planning, 701 Main Street, Lancaster, Mass. This public hearing notice was published in the item on November 23rd and December 1st. All project documents under consideration at Board of Appeals can be viewed at the of Lancaster Appeals. So what we have tonight is we have a letter from Christopher Elton. And I think we're going to start with that letter and go through. It's kind of a summary of where we're at tonight from when we started in December. If you have any questions, we'll get those squared away with you. When we've finished going through your letter, we will see if there are any other people in the audience or on Zoom that have any comments, concerns, questions. Oh, we have Bill and we'll get to. Then we're going to look at Attorney Costa's starting an approval, additional approval, those areas, see what you want to add. And at the end of the night, we'll see where we're at. We feel we're comfortable in ending and closing the hearing. We will close the hearing at the end of this evening. We feel there are unanswered questions or concerns or things we need. We will ask you again, Chris, for a continuance. Understanding that next week is our normal meeting. I will not be available. I will not be available. So we would ask that you possibly give us an extension into October sometime. I know the first Thursday in October, Eric's away. Hopefully the second week in October or the third week, we can all.
The 10th and the 17th.
The 10th, 17th. We'll talk at the end of the.
We're always willing to work with you.
Yeah, so that's kind of what I think I'd like to start doing tonight and see where we go from there. So, Blackman Bobrovsky letter, it's a letter from Chris, and it kind of goes through everything we've done so far. Gives us a weight. I have questions on your waivers. I thought there was a while back where you gave us a list of waivers and we kind of said, no, you're tailing what's satisfied this, you satisfied this, satisfied that, we don't need it. But now I look at your waiver list and I see a lot of those things that we thought weren't needed are back.
Yeah, I don't know if we put anything back, for the record, Jenny Christopher Alton for the applicant. I don't think we put anything back. That might be very well true that you don't have waivers that we don't actually need, as a peer review may have said. I tend to just be over conservative and keep them in there unless in case there's a different legal interpretation by somebody. So ultimately, in your decision, you may decide, this is the waiver they're requesting for, they don't need it, and we're gonna not have any objection to that. If you go through the waivers, it really is too many waivers that we're seeking that we actually need. We're talking about use, we're talking about the multi-family use, we're talking about some dimensional waivers we need. But other than that, a lot of it, to your point, is about procedure, which we don't actually need waivers to because this is a comprehensive permit under 40B. So no disagreement that there may be waiver requests in there that we do not, in fact, actually need, but to be careful and conservative, I keep the requests, you know.
So, looking at the waivers, I guess the first waiver is for 228 under the use regulation to allow multi-dwellings in a residential district. And I kind of think that's a given. And
Yep.
please, if
Yep.
you disagree with anything, just let us know, okay? Adam, you too, if you have any comments, don't be afraid to interrupt.
Dennis and Eric, did you guys get one that's marked up?
Yeah.
Oh, okay. Those are my notes.
What's the matter? Oh. Frank, were you able to get these documents?
Oh, I apologize, they're supposed to print like this.
No.
Frank, were you able to get the letters?
Yes, I have them. Yep.
So the second request for waiver is 220-10, which is lot dimension requirements. The bylaw provides a minimum lot area of 87,120 square feet. This locus contains 24,743 square feet. Bylaw requires 220 feet of frontage. Locus contains 175.02 feet of frontage. So they're requesting a waiver from these requirements to construct the project at Shannon. Everybody in agreement to that one?
Yep.
Okay. Yard dimensions 220-11 by setback requirements. The bylaw provides a minimum front yard setback of 30 feet. Proposed project provides a front setback of 8.6 feet. The applicant requests a waiver from these dimensional requirements to construct the project as shown in the plan. Okay. Right?
We did have a communication from Scott McDonald today that addressed that. It's fine.
He's okay with that.
My apologies.
Next one is section 220-22.c, required off-street parking. This provides that each parking space to be a dimension of 20 by 9, and they are proposing parking spaces 19 by 9. Requesting a waiver for that 1 foot difference.
And Chief Moody had indicated is,
Chief Moody said that was okay.
he's not crazy about it, but it meets compliance.
Yeah. Okay. So I just want to go back to the 22011. Section C of 22011 requires certain landscape requirements. The applicant requests a waiver from these requirements to build this project.
He has provided a landscaping plan.
Right. It's just he didn't list it as a waiver section number. He kind of put it into the comment section. So I just want to make sure that we do mention that. That's okay with everyone.
Yeah, we'll be covering it, but
Yep. 220-22.1 curb cuts. 220.22.1 provides a process Permitting curb cuts. Applicant seeks a waiver from this section. Zoning Board of Appeals is provided with the authority to issue all local approvals. The applicant requests a waiver from the curb cut requirements to the extent necessary to permit the project as shown on the plans. I have a question on that. Curb cuts cost money. You have to pay a fee to the DPW. So if we grant the waiver, are we saying they don't have to pay that fee to the DPW?
You could be, but I'm trying to remember is whether there was a request. Or should I just tell you, you request a waiver to our fee waivers of all fees.
We did for the affordable units. And the clause, I don't think we requested a waiver for curb cut.
So this is something that we've seen with other applicants years back. Where fee waivers have been requested. Sometimes those fee waivers are any amount fees that might apply to the project. Other times those fee waivers are more specific to the affordable units and some developers request fee waivers. So that's a decision the board will have to make. It sounds like in this case they might be asked for a fee waiver as it relates to components of the project set apart. So you would want to be specific if you choose to grant this procedural waiver, which I will tell you it applies to this waiver we're discussing now, and several others we're about to discuss. As Attorney Alpha indicated, he's very caution to speak and requesting waivers for procedural requirements. I don't agree 40 days requiring that. I appreciate when he's done it. I've done it in the past, represented private applicants, better safe than sorry. But it's very clear from the statute, the regulations, that the Chapter 40B comprehensive permit process, the very concept of one-stop shopping, is that this zoning board of appeals stands in the shoes of the various other permit. And so, by virtue of issuing a comprehensive permit, you have effectively issued and no. But I appreciate why the request is made. So you could grant the waiver if you so chose, but you could drop a footnote in the decision or include a parenthetical that indicates, provided however, the fee will be paid by the applicant.
Is this a waiver that you're just throwing in there, or is this something you
Well,
really
it's in
don't
the
meet?
zoning bylaws, and we're not seeking a waiver for the curb cut fee. That's not part of it.
But you're seeking a waiver for the curb cut because you can't meet the requirements of the curb cut. So,
Well, I don't know if that's true.
I don't think it,
There's no requirements, but there is a process. So you're correct, it's more of a procedure request, but this is what, it's correct. Request.
Right, so there's a distinction here, actually. I don't know, it's like a policy. You're gonna come up with some procedural waivers and then some. So we can capture those procedural waivers, whether you want to choose to vote one at a time, as the Attorney Alpha stated out, or you want to include a blanket statement that to the extent that the zoning bylaw requires processes and procedures inconsistent with the process and procedure prescribed by Chapter 40B, this permit just needs to waive the process. You can include a statement to that effect. But it's true. Again, my perspective is he doesn't even need to ask for it, but I appreciate why he is asking. But my understanding is that it's purely as related to curb cuts. It's purely the procedures for seeking the waivers. I think they've met. I'm not even sure there are specific curb cut requirements, but to the extent that there are any requirements that apply to curb cuts, they permitting or with the curb cut, it can be.
I mean, the fire department, the police department, they talk about the turnarounds,
Yeah.
the curb cuts, width didn't really come up. The 20 feet.
so then, I like the idea of Adam, this is a procedural waiver, he's asking if we do that blanket statement in the end that covers them, but doesn't allow them not to pay the fees.
Right.
Conditioned upon, they pay the proper fees. Next one, 220-23, the minimum number of spaces.
Madam Chair, this is right here. I didn't see, this is another over the top request. There is no minimum parking requirements for a unit or residential building. Are there?
No.
No. So I with this request because there seemed to be a lot of conversation that we wanted to see 2 per unit, but we can strike this request as there's no requirement for a unit. Maybe there should be, but there isn't, so we can strike that request. I just put that in there to be conservative, because I know that the board was asking about 2, and I wanted to point out that there's only 1 point.
Right, and that could be a condition of an approval is that, we have 1.8 parking spaces per unit.
Yeah.
Article 8, sign regulation. So this section regulates the installation of signs. The applicant requests a waiver from this section to erect signs as shown on the plans. Want to elaborate on that a little bit? Because
I think the elaboration is just whatever plan. Plan. And I think one of the conditions of the decision is to put up some no parking signs and things like that. And so, the waiver request would be signs actually on the plan or as required.
and there's just mostly no parking with the stop signs going out. Correct?
We're looking on parking sign at each building.
No parking on Neck, no parking on Center Bridge. Stop sign
Yeah, stop signs at the end of the driveways.
going out on Center Bridge. Are you gonna have a do not enter on the Neck Road? So, no, I'm sorry, in the Center Bridge Road side, do not enter.
The other side of the project.
Yeah, you're gonna have a sign on the building for naming the project or anything like that, a freestanding sign?
And there's handicap, accessibility signs.
Yeah, handicap signs, yeah.
Way up. Charging stations.
Are we okay with,
And just to clarify, because I did get a question today online, I think at one point we did discuss the 4-way stop, the intersection.
I sent that to him today.
That's not under the purview of this application. They wouldn't have, that would be a police and DPW requirement. That wouldn't be, we can't make them responsible.
so the, sign reg, is it okay with leaving it the way it is, or you wanna?
I know we have some things in our, it's,
Yeah, I
and
know,
there's nothing in the plan that makes me think they're,
they're not gonna.
they're trying to do that, but general blanket. I remember we went over at the beginning on the height of the stop sign and stuff. Yeah, but our bylaw includes like that. So I think everything we've talked about, the stop signs, the traffic sign, you know, or a small sign, or the name of it, that type of thing, I have problems with, but a blanket waiver overall to that requirement could allow logoing to go on the building and stuff like that, that's not shown. So I guess if there's a way to safeguard against that, by it's not on the plan, so it can't happen, I'll get to the last.
Yep.
Town council on that one.
And I think that's actually what the waiver proposed, the way that it reads, it says the section that regulates the installation of signs, the other question from the section to erect signs as shown on the plans.
Right.
So they're only seeking permission to correct the plan. If they wanted to add additional signage to the building or erect more signs beyond what's been indicated in the plan, that would be inconsistent with the waiver. I mean, I'll be candid, this is somewhat of a, I won't call it a blanket waiver, sort of like a blanket waiver light. It's not a blanket and granting a waiver from everything that it can bylaw to the extent it's inconsistent with what's shown in plans. But it's not, I think, in the sense that the applicant has gone through the sign regulations and said, I need the maximum square footage. I think it need the maximum height. We don't know what the provisions aren't satisfied, we just know that there are some provisions that aren't satisfied. Your sign bylaw also doesn't closely regulate direction sign. It's like, you know, stops. Sign bylaw doesn't concern the sign. Project. Is that going to be 10 feet by 4 feet, or is that going to be 18 inches by 2 by a foot, right? So there's a difference. So if you're comfortable with showing the plan, then we don't have to go through the provision of the sign bylaw line by line. If if you are concerned with what's in the plan, or you want to know the extent of deviation, we would need the applicant to explain what provisions within the final plan.
Is there anything in the plan that shows with this building?
All of the renderings of the building they did have. Remember seeing it somewhere.
I'm seeing everything in the advertising in the.
Is there on the renderings?
Yeah, so I thought it was on some of the renderings they gave at one point in time. I can even say, like, that would just be my concern.
Yeah.
Getting that, that we're all comfortable with the size.
The elevation plans have stand on the sub elevation, right? It's a net farm. Not the site plan.
Okay, so, very good. Yeah.
I don't think it was.
Yeah, we don't really have signs here. I mean, usually typically when we request a sign waiver, it's because we have net farm stakes or something. We're not even proposing that. We're basically just following conditions of,
Alexa,
yeah, I don't even think they really need it.
pass the timer for 6 minutes.
If we include that shown on the elevations.
Starting now.
There's one.
Next one, section 200-34.
Wait,
Section-
is there something? Yeah, okay, so on the elevation,
Right, so, yeah.
yeah,
That is our control.
there we go.
So 200-34 contains design review criteria under site plan review. The applicant requests a waiver from site plan review to the extent necessary, as this is a comprehensive permit. Again, I think this is a procedural, so. Yeah, blanket. Section 220-35 provides design guidelines for any new building construction under site plan review. Applicant seeks a waiver from this section, the zoning board of appeals provided with the authority to issue all of the approvals. Again, I think this is procedural.
Okay, you're already withdrawn this.
Are you with this waiver?
Yeah, and these are both procedural.
On. 220-36.2, this section provides criteria for lighting on the property. The applicant requests a waiver from this section to the extent necessary to permit the project. I thought you withdrew the lighting because you could meet our lighting requirements. It
Yeah.
wasn't a big deal.
I think that's right, we ended up confirming that we need to.
So that's not section 220-37.1 B and C. Landscaping, the applicant requests a waiver from these landscaping requirements to the extent necessary to permit the project as shown on the plan. Street plantings would be required on Center Bridge Road. Proposed plan does not contain plantings along Center Bridge Road. I think being such a tight area and having the buildings you're gonna have, I'm not sure how they could meet our landscaping design, so I have no problem with that.
I think we're better off sticking with that.
I agree. 220-37.2, erosion and stormwater. The applicant requests a waiver from these requirements and states further that the project will comply with state and federal regs. Is that close?
Is it that we're gonna comply with mass stormwater? And so any sort of criteria under your local bylaw, we're asking for.
Bethany, right?
My comment on it is really if the conservation commission has had what their position is. They do comply with the stormwater requirements of the state. I just, in my opinion, I think that the conservation commission should still have a setting of it.
I think in Adam's draft, we talk about conservation, right, Adam?
We do it in past, so just a reminder to the board, so the way that it works in for typically. The Conservation Commission contains. That's typically the protection, although it also includes stormwater process be required before the Conservation Commission under the mass stormwater standards. Lancaster, it's not the Conservation Commission, it's related to the plan.
Yep.
That's included within your zoning bylaws. So when we talk about wetlands, it's not. And we talk about wetlands, this is where I reference the Conservation Commission, those conditions. Our waivers requested, and we'll get to them momentarily from your local wetlands bond. And that's sort of typical for a chapter 40 for that project. Although it's not in this case because this project is not in close proximity to wetland research. It's the pages of the waivers required. So there will still be a process before the conservation audit. Under the state wetlands protection. With respect to stormwater, the question here is, should they be required to apply for waivers for any standards within your zoning law, typically administered by the planning, that would be more stringent than what the mass storm. Without seeing it itemized as to which of those provisions would be applied to the plan. I don't know if these would be really included in reviewing any of the stormwater plans or under the local bylaw, or whether that review is restricted to the state standards. Maybe the state standards correspond.
Everything you looked under stormwater has been on the state standard and not on the town state.
If I recall, I think it was actually a copy that I wrote out in giving the board's first letter. It's defer to the board with respect to reports.
Local bylaws is pretty until an acre.
That's true too. Stormwater doesn't apply until 1 acre. They have less than 1 acre, so our bylaws probably wouldn't even apply this project. You have to disturb 1 acre to have stormwater with the planning board.
So I can take a closer look at it. You're not going. So before you vote the waiver, before you sign it, you can go closer to bylaw, and if it's determined by station, I think further council as well, that it's not simply true. You can make it again.
If it's not triggered, we don't even need it. Uh, 220-38.1 parking design. The applicant seeks a waiver from this section of the zoning board of appeals is provided with the authority to issue all local rules. Is this a procedural one as well?
Correct, yeah.
Next one. Section 225-54 and 55, building permits and occupancy permits. The applicant requests a waiver of payment of any fees associated with permits for the affordable units. In my history on the board, we've never waived the fees. All the 40Bs we've had. Although I won't start waiving fees of anything, I think the town needs every dime they can get, so fortunately, I would not be in favor of waiving that. The rest of the board feels. Frank?
I agree.
Great. You?
I mean, could we ask them to usually not providing those fees,
I mean, it,
economic hardship?
yeah, it is paying those fees for those 2 units that you're gonna have affordable is gonna make this project uneconomical?
I just think it's customary, it used to be the day that all fees would be waived for 40B projects, the entire project. What I do is customary, which is to connection fees and permits that are just related to the affordable units. And in the spirit of them being affordable units, pay those fees. So in this project, it's either gonna be 2 or 3 units if you're waiting for fees for. So I see that that's appropriate, that's the customer, that's what everybody's asked for, for representative boards, that's usually what I ask for the grant. But it's serious.
But it's not gonna make the project uneconomical if we say that. You're still gonna be okay. No, yes? You don't, you don't know, you're thinking that. We've all said we're not in favor of waiving fees, Adam, so I don't know.
So every decision on a waiver, every decision on a potential condition, puts you at risk of an appeal and challenge that condition, that waiver denial renders the project. So you have to make a effective call in each case as to whether you think it's a straw that breaks the camel's back. I don't disagree with anything Attorney Malcolm has said in terms of how it used to be, how it is, whether it's customary, whether it's the practice of any developer's attorney to seek waivers, wholesale waivers from fees when we put more to affordable units. I also know that the practice of this board, for as long as I've been representing you, which has been 15 years, has been not to grant these waivers. Any of the comprehensive permits you issue. Does that mean you should deviate or not deviate here? That's a decision for you and not for me. I have no sense of what the fee would be, so it's also hard to discuss the back and whether the run of the project and economic. We probably have a sense of what the numbers should be overall development costs of the project. That's obviously numbers the application. What are we talking about dollars and cents here? And then you can look at that relative to the overall development costs and say, again, use that average, it's going to be strong. It's a decision in your discretion. I've heard all those, so I think that's a no. And if you change your mind before you sign the decision, you can change your mind before you sign the decision.
This last one, I think it's a Board of Appeals Rules and Regs, section 320-40 application. So this section requires the applicant provide 10 copies with the town clerk. The applicant will provide sufficient copies to the board and will provide an electronic version to the town. This is at the original application, correct? So this is kind of.
We're just in for
I guess yeah, I mean, this happened back in November. It's not a big deal. So now you go into Exhibit A2, stormwater management rules and regs. Chapter 205 or 305?
Should be 305.
305 first?
Actually,
I drafted it a year ago.
Stormwater management rules and regs, the applicant requests a waiver from these requirements and states further that the project will comply with the state and federal regulations. So isn't this just a repeat of what you?
Yeah, one's the bylaw. This is one's some stormwater regulations that regulate things that the planning board properly uses, and then one's in the bylaw that triggers. So. Right, it's the same issue.
Same mission, and I think once Adam reviews this, and we'll let Adam review that, I think you're gonna find something. And then the last two, Lancaster Sewer District and Water Division. We believe the following waivers are required for issuance of the comprehensive permit, and therefore you request the permit granting authority to issue waivers relative to the following: the Lancaster Sewer District and the Lancaster Water District. You're seeking a waiver of payment of any fees associated with any sewer connection extensions or any related fee for service required for the affordable units, and a waiver of payment of any fees associated with any water connection extensions or any related fee for service required for the affordable units. And again, I think this is something we don't have the authority to grant, correct? The water and the sewers.
Well, you remember the new. So the role of your board could be some.
Yeah.
We discussed, ad nauseam, context of clear for the states, the authority of the boards of Board of Appeals as it relates to the authority of the water department and sewer district.
Yeah, sewer district.
Sewer district. the reality is that whether it's a district, it's a department, whether it's quasi-independent or not, there is case law that indicates that the buck stops with you as the zoning board of appeals as it relates to issue those connections. So for purposes of the connection, the fees that will be associated, you have to issue a permit, and you have to decide whether the fee is to be made to question court. That's different than this case. The cost of purchasing capacity or conducting II to create an asset as this. Those are issues that are not within you because they're governed by the administrative consent for the issue on our reviews to this. So, and we get to that proposed condition, I question whether I should mirror what we had crafted for Weary Brook Estates, which was fairly verbose.
Yeah.
I opted to do it because I think it's necessary in the context of this project. The same dichotomy between working about authority. But for purposes of this waiver, this does fall
This
under
way.
that. You have to issue the connection permit as part of the comprehensive permit if you choose to issue the comprehensive permit. And you have to decide whether to make this.
Okay, so, again, we've never waived fees, I'm not in favor of starting now. So I would say no on both of these.
Yep.
Yep,
Okay.
and Frank,
I agree. Nope. Yeah, we're not gonna waive any fees.
okay, so, those two would be no. So that covers everything you've asked. Any concerns, questions, anything?
I guess turning to the next set of things, at the last hearing, we talked about making some revisions to the plan which we've made. So we can talk about that. We can talk about the decision, and we can talk about the test conversation we had at the last hearing. I don't know if there's anything. Okay, so first, I don't know if we just want to quickly, Joe, go over the revisions that we made to the plan after our last conversation. There's just some lining up that we had to do. So we made revisions to the plan.
Is it something that you can share on the screen, or is it something you're just gonna?
Looking at here.
Oh, I didn't know.
Plug it over there. What do you,
Thank you. And then new plan.
sheet three?
I think, or, yes, each sheet is the same.
Okay.
So the largest thing that we did was relocate the existing sidewalk out onto the right of way. So we have the crosswalk running across the entrance way. So we just kind of realign that a little bit, cut it out. That it's going right from, right on the edge of the right of way to, off the right of way, comes down, gets to the end of the property and, get back on to the existing walkway here. This section of walkway is, concrete, the section across here is bituminous. And Mr. McDonald asked that we do the new sidewalk in the sun. We also, so that gives us a little bit more breathing room on the stairs. And we, go to the next sheet with look at,
And just one question, I know we spoke the other day, but if you could just elaborate, the utility pole number 3, that's existing.
yeah, there's a utility pole, number 3, that's kind of, partially in the relocated sidewalk. And under the access regulations, we're doing a 5-foot sidewalk. Under the Massachusetts access regulations, we can have an obstruction. And this exception is written for utility poles, hydrants, signs, anything. We can have a 2-foot obstruction as long as we don't reduce the clear capacity to less than 30 feet. That kind of falls in play here. We can work with that, and apply with that and not have to relocate or touch that. Because it's a lot on that pole, so we don't want to have to do it. So we looked at the grades here, and adjusted the stairs. We've added a connection to the sidewalk here that was not here. And then looked at access over to the sprinkler room and made sure that the ramping works, get the handicap here. Then we, added a connection here and a stair here for the barn. Here for the porch here, and this entrance will be, this entrance and these 2 entrances make that accessible. And we provided an additional walk here to the door here, and an additional walk here to the door here, for that we can back up the building. So that's the layout changes, and these corresponding changes to the plan, with those elevations, the the slope where we have to, the stairs and all that works, and we updated the landscape plan so that we just road bushes and around that was really it. We got those plans over to and I talked about concrete, 2 minutes. Yes, how close we were going to be to the right of way, how close we were going to be to the edge of pavement. He wasn't crazy about the 1 foot, he would like to get more there. But we're about 4 feet off the edge of pavement. And he's more interested in that separation, the rest separation, we're safe.
Yep.
Than he is across. And anything there. Construction tolerance. If you're saying it's off the right of way, it will be.
So it's 4 feet off of the edge of pavement, so, right.
It's 4 feet off of the edge of pavement on Sunbridge. It's 1 foot off. There's a healthy higher than the edge of pavement. So
The stairs you added to the barn, that's just going to that first floor door.
okay, that's an egress.
Trying to compare it to the architectural.
Then your fencing going up on the pillar off to your property. Yeah. You have shrubbery planted in there,
I'm gonna go
you have the
a
land,
lot. Not just for,
three trees,
yeah, the project and that's,
sorry,
the layout plan shows the snow storage and kind of looks like.
and what is the, depth?
The depth here,
Yes,
I believe it's. I'm
3 trees,
not sure. 3 feet. 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 3
And that's curbs, correct?
Yeah.
And do you know how you're going to be plowing this property? Are you gonna be pickup truck plowing?
What kind of curb is it? Flat curb or?
You know, whatever gets snow off.
Yes, we were going on that edge, it would be, it kick on, asphalt from the and we don't, it's pretty simple driveways, but it's probably just a truck. Trucks, it would be, we understand when you look at the conditions, the proposed conditions, there's a proposed condition with regards to removal of snow. Obviously, if we have to remove from the site, then we'll have to loader. But for your run-of-the-mill storms,
And that triangle on the corner where you have the tree in it, is that still being proposed for snow storage?
yeah.
Is including UK cities. It's where you can visit the Ulster Museum and nearby botanic gardens.
What I think will happen, from a functional standpoint, is
Sorry, somebody's,
I'm trying to mute somebody.
office. Get the hand.
The way that functionally will be plowed is they'll come in and do the first pass. And then they'll have to work with the management team and the residents of the cars. So it can be a lot of backplane and manipulation of the actual parking space. The other thing that's important to note here is, of course, pavement tends to melt. It has a direct connection to the warm ground below that comes up and tends to melt faster than nothing. I mean, for those areas, if we say, they would use that for the storm.
For temporary storage and then that's.
Right. And if you guys can see, kind of come up with conditions that talks about removal of snow, that is tied to the.
So that's
They
something.
left that line or what the height is, and then we can talk about. Obviously, in that condition, it says, no, will not. The number of parking spaces and the. Right.
Okay. So the revision to the plan. Next.
I think we're just going over because I know snow removal, just to put sort of a cap on that. I know in the draft decision, there was sort of a blank there, but we agree with how that condition is written, which is we're going to utilize the storage, snow storage areas. We're going to make sure that the parking areas and the driveways are clear. My clients own a bunch of properties. They know how to get snow off property. They have to comply with that condition. They're not complying with that condition. It's a violation of the decision, and they can be fined by building inspectors. We think that issue has been resolved.
So I think,
I
I think in the condition, we have to come up with how many inches or
Yeah.
something.
So, well, that'll be in the phone. Structure, that's where it is, that's what you're talking about, that windrow on the corner.
Right.
Yeah, so I think we have it on that spot,
So there's a couple of elements to the decision of storage. There's the question of the snow storage area obstructing portion of the center where visibility could be a problem, most notably the intersection of Bridge Road, which is where we was going to be exiting. I was concerned about it because it's all
It's only coming in.
But that's a concern. I think there's also, although I haven't considered, but I haven't to raise, as we discussed that condition, there's also that site, sort of a different intersection. So those are areas that are sensitive areas that we need to address the extent to which that further occur. Having said that, when I started looking at the site triangle diagram prepared, Mr. President, and showed the site triangle we needed to be much clearer. The majority of that site triangle, if not the entirety of the site triangle, is actually outside the site because of the fact that the point when an intersection between Centerbridge Road and the exit from the site right of way is so far into the right of way. There's really no issue with stacking snow from the side. You're not sure stacking or hot from the right of way, which they have control of that's for temple acts. But then there's a second snow storage component, which is interior to the site. So not areas that are sensitive because of visibility, but just because at some point it gets so high that it gets not really on the site. So you have to determine the appropriate height there. I look back to those we discussed a couple of different meetings. There was some back and forth in the engineer's discussion for the traffic consultant's discussion, but nobody chose a particular appropriate height. So I left the plan to be determined. Usually it's the height of the storage area. So you can do it by storm. Any storm you get more than several inches, but the problem there as well, what if the limit is any storm of more than 8 inches? And you get 4 storms in a row, 4 days out of a 1 week, and each storm is 7 inches. Well, I have 28 inches of snow on it, and no single storm surpassed the threshold. So the better thing to do is to maximize the height of these storage areas so they can do whatever they can do to squeeze onto these areas. They can spread it out, they can move from one area to another area, but once the area gets over a height of whatever, 5 feet, 7 feet, whatever the number's going to be, I'm sure they have to. There's a practical component of it, which is like I mean, here the driveways and parking spots are going to clear them very close to they can. But the idea is that within a reasonable period, immediately more or less the next day, their operations going to try to stop wherever they try to.
So that's what I don't understand is. So they're gonna clear the parking spaces and push the snow to this 5-foot area. As a berm, so they're gonna be lifting. How, you're only using a pickup truck, a plow. How are you putting snow 5 feet high? You can't put a pickup truck.
Well, it's just, no, the Cape Cod berm is only 4 inches up.
Right. But
And
you,
tapered. And tapered.
and take, yeah, so you're gonna push the snow.
The plow puts the blade angle and hits it, and the snow's moving across the blade to the windrow, to the 6-foot upright. I just mentioned, it's actually on the plan, 6 feet on the back side, where this windrow will be extended. So, as just like big problem trees, you get a snowbank inside. So it's gonna. That's the bottom of that berm, that asphalt Cape Cod berm, is where the aisle, the 20-foot aisle. So he puts the blade right at the bottom of it. It's going to come off the blade and make it outside. And that's.
There's a little bit of understanding when you're plowing snow. Yeah. I mean, anybody that plows snow, if you've got no room to push it, you can't just leave it in the middle of the road.
Right.
I mean, you gotta be, whoever's in there doing it will have the equipment and knowledge. They have to bid it like that to clear it out. So yes, very quickly, if you've got a 1-foot storm, they're gonna be hauling it out, they're gonna be trucking it, they're gonna be moving it quickly, but they have to keep it clear first. So there's a little bit of forethought and that has to go through with the rest of it. There isn't the space there. And there's plenty of other spaces. It's not, there's plenty of places that aren't, but they'll just have to deal with it and then they'll have to haul.
So we have.
So very quite possibly after every single storm, unless we get 2 inches, which there's plenty of space there for that.
Yeah, but what I'm trying to figure is what is the minimum that we have to say,
yeah.
Because for the snow, you're gonna knock the 6-foot fence down if you're gonna try to put it 5 feet high, because you can't with a truck. You know what I
There's
mean?
a lot of a lot of, I mean, if it's sunny out, it's gonna be less, but there's so many unpredictable parts to this. It's the middle of the night, it's not gonna melt, you know, it's.
So we have to come up with something
Right.
for that condition.
If it provides a frame of reference for the board, this is kind of a common condition that become more and more common. It's recommended, because evaluation. Very interesting element and often you have limits. I've seen limitations as low as 5 feet. I've seen limitations, they're actually max, right? Limitations, they're max, I've seen max as low as 5 feet. I've seen maximum as high as 10, 12. Part of it depends upon the location. So to your point, I understand, well, how are you getting this to allow?
Yeah.
Well, I think what it is you're pushing it again, eventually it's just building.
Quite possibly they could be in there with a little load.
The issue that tends to rise is concerning this, well, at some point you're pushing.
You're pushing against that fence,
You're
that
pushing
might
it
be
to the
going.
fence,
Yeah.
initially.
Yeah.
So you'll see when we get to the fence provision, that we've got requirements in the fence, perpetuity, if any damage, repair, it has to be for that example. In all likelihood, they're not going to refuse to do that. They're just going to find that.
I got a little concerned with the high storage on that center and being able to see around.
You mean that triangular corner?
Maybe want to limit that. Well, basically, think about it from a space point of view. Now, they're not gonna be out there with a snow shovel and some water and pack that thing in a cone 5 feet high all the way around. Agreed. So they're gonna be pushing it in with a plow, and quite frankly, I don't know whether 5 feet of snow will fit in there. It's just gonna fall back off. So, I mean, you gotta think of that part as well. It's definitely a practical limitation of how high they are. Right, it's just not gonna, I mean, you can't start at 30 feet high in that 6 foot rounds. Yeah, you don't get enough speed or enough room to get in there. Right. There's a normal amount of practicality with the snow. But I guess we have to maintain it, it's like, that's just, we talked about the safety off the property, just making sure that included in there is the safety of movement. I mean, think about when we get a big storm with the, there's a lot of sidewalks that are hampered, corners. I mean, then the next day they go out and remove them and push back. Right. Nothing has happened immediately. Right. We were to say, okay, there's no room offsite. I mean, quite frankly, from another point of view, if they leave it there, then they're out of snow storage starting next door, and it's gonna be 2 blocks. So they're gonna shoot themselves in the foot.
That's something we have to think about, the condition. Anything else you have before we go into?
I just wanted to make sure everybody understood, the test pit issue, there's some back and forth with the conservation agent. There's some conversation about it at the last public hearing. You know, I just want to make sure that the board should what's going on. I turn it over to Jeff to understand this. I think we need to clarify what happened.
Is that the different modeling in that thing?
Yeah. Simply stated. Well. Do you have any questions with that from seeing whether it was inconsistent or if something didn't seem right with regard to it and suggested that additional testing be done with this confirmed witness? It went out there, it's a certified soil evaluator and her, also certified soil evaluator. They made an assessment, they rectified the confusion, what happened. And all of the water table in the back tests lower. So it's not an exact science. In looking at the documents in it's what in the first soil evaluator was overly conservative or saw something that they didn't. So that's it. And working on us, for the new engineer. And so, evaluated all of the.
Bethany, you were satisfied with them, you were so, correct?
Yeah, so I have no idea where they put the first evaluator in there. There is quite a distinct change in color from one horizon to the next one. So I think maybe when he was observing it, he might have mistaken some of that for modeling, which is what indicates high groundwater. But we didn't see anything that would indicate groundwater that was that. And that includes things that are not seasonal, like the techniques, like how do you observe the growing in that test pit. And we did observe the storage well below the original estimated high groundwater. So I'm pretty confident that's not. I just understand that the conservation agent, when you design these systems, and you have working information in these pits, you're supposed to take the most conservative information. But in this instance, I disagree with that. I think that we should go with the second set of test pits that I was out there for, because I think that that's much more accurate observation. And I also think that it was more consistent with the soil complex that we were expecting to see there. The first test pits they observed reported the observation of medium sand. There's no medium sand there. It's all sandy loam and fine sandy, and that tracks with the soil complex description that we would expect.
You say the soil is wrong, fine sand? Said fine sand?
Typically, sandy loam and fine sand.
Great, so I just wanted to clarify that in for the public. So, other than that, I don't think we have any.
So, do we want to start going through Adam's conditions, or do we want to open it to the public first? And the time is, say like an hour. If they have anything that could be added before we go to Adam's conditions, or do we want to go to Adam's and then listen to the public? Because chances are we'll close the hearing tonight, and once we close the hearing tonight, so the public knows that no more information that you can get. The hearing, we're into our part of it, working with our attorney in drafting conditions for an approval or a denial.
So as much as I would like to give the public a chance to comment earlier and not necessarily have to stay all the way to the end, I think with the fact that we didn't get these draft language posted for a chance for them to hear it, and maybe they might have comments particularly to the condition, I'd rather recommend we go through the document and then give them comment.
Okay. All right. So,
So I have, and well, here you all have copies, and see, I have copies, and I don't get a bunch, so if there are members of the public.
yes, say Bethany, make sure you have one.
Probably 7 or 8, so, so we had discussed drafting of conditions and not a full decision. So I just put it in the form of a decision, so I can fill in the blanks and the remaining portions of the decision later. So what I'll try and do here, I'm just going to describe the topics of the various conditions, and then if you want to them with as much or with little specificity, and like one can read. So maybe you can take questions about that or even recommendations. Just for context, what I did was I worked off the last decision with respect So that was good repurpose date, that was, 6 ago now, 2018, I think it was.
Yeah.
That was a much more complex project, a much larger project. It had both rental components. And the economics of that project were very different, which resulted in discussions of various conditions of approval requiring things like cost offset improvements. So there was much of that wasn't particularly applicable to this project. So what I tried to do is I went through it section by section, condition by condition. I struck those provisions in more relevant. Those that were modified almost every condition to be specific to this project. And then once I had done that, I went back through my notes and various signals, which is great that Brian posted all on the website. You go back and make sure I had it. And literally read through almost every one of the 30 or 40 or 50 documents there. To be sure that I so I think it's fairly comprehensive, but you may have different notes. So I think you say you misstated this, you miswrote it, or you just missed. Yeah. So at the beginning of the bottom of page 1, Roman numeral 4 conditions. We divide these conditions. I divide these conditions into different topics. It's just easier when you're searching for a condition. 6 months, 5 years after the approval to know what it is you're looking for. Is it a construction condition? Is it a legal condition? Is it a condition that deals with the site design? So the first topic is just documents. Incorporate the documents plans that have been submitted so that the applicant knows, the board knows, the public knows, and most importantly, your enforcement officials know what it is that is being done. So condition number 1, the project shall be constructed in substantial conformance with the documents and plans that have been submitted in their latest iteration. So lowercase letter A are the site plans, which were last revised on September 3rd and consist of the 5 sheets that are listed here: title sheet, existing conditions plan, layout and materials plan, grading, drainage, and utilities plan, and the landscape plan. And then lowercase the letter B, floor and elevation plans with concept rendering views. Those are what we saw at the last session of the public hearing, showing a couple of different perspectives with renderings as well as the floor plans and elevation for these, what are now 2 buildings total.
Now, would we add in this new plan that he showed us this evening? Would we be adding that?
I think that is the September 3rd plan. That's the latest version.
That's okay.
So the only thing that hasn't been updated, and I guess I'll have to do this, maybe I should changes were made by Mr. Benbow of the plan. We'll look back at the things, the 2 that were provided, to see their consistency, because we discussed at the last meeting, right, that it was just described to you that there are areas in locations where they weren't before.
Yes.
Some of that is not going to be shown in the rendering, so what I would typically do is I would include just a sentence at the end here saying, in the event of a conflict, if the rendering of the site, the engineered site control. You don't necessarily need to redraw the rendering. The rendering isn't binding anyway. I think it needs to so, but it's indicated here in the site controls in the event there's a condition 2 just summarizes the composition of the project. So 2 multifamily buildings, the farmhouse building, which has, and this is my estimation, I actually didn't see this summary written out textually anywhere in the materials, partly because it's changed in the recent weeks, months, where there was a description of the bedroom counts, but also the bathroom counts accompany each of the bedrooms. So I don't know if the Attorney Alpha had a chance to look at it as well. I'm sure that between that, the meeting, which is going to Senate, correct? I think we've got the farmhouse style building that has 2 2-bedroom units, one with 1 bathroom and one with 1.5 bathrooms. 1 3-bedroom unit that has 2 bedrooms. Then you've got the barn, has 2 1-bedroom units, each with 1 bathroom. 4 2-bedroom units, each with 2 bathrooms. And 1 3-bedroom unit. I think that's the proper tally just based upon the floor plan that were provided. And then I included the standard language, included another decision saying there shall be no conversion of additional space within a unit into a bedroom. That's important because you're basically improving bedrooms. You want to make sure that there's no Paragraph 3 says no storage, common area, or other area designated on the plan as part of the unit shall be additional dwelling unit, so you're gonna have 10 units now, you're gonna have 10 units in the future, there's not gonna be an additional unit without modifying the permit. Condition 4 has already been alluded to in the discussion we've had tonight, which is parking space tally. I think it was stated to be 1.8 units per space per unit.
We add that in there.
I didn't do the actual calculation, although the number was such, you would say 1.8 times 10 units, it's 18 spaces.
Yeah.
I've said here a total of 18 parking spaces. 8 parking spaces are equipped with electrical vehicle charging stations, those are shown on the plan. And then again, I tried to strictly cater this condition to capture my notes from the various sections where you discussed potential parking problems. So what I've said here is no on-street parking, whether on the adjacent Centerbridge Road or the adjacent Neck Road, shall be permitted, and appropriate signage to that effect, let's say that effect, not that effect, to that effect, shall be installed as shown in the plan to the applicant's expense, contingent upon and subject to receive necessary permission. Slightly, that last phrase is in there because my understanding, and again, the applicant these no parking spaces, no parking signs are going to be located within the right of things. They don't have permission to do that without the signs. As the entity in whose care they control the public ways.
Yep.
I also say nor shall vehicles parked or idle unattended for any extended period within the driveway or aisle, internal locus. In other words, they can't park where they shouldn't be in the driveway outside of the parking spaces. And these restrictions are enforced.
And I know it's on the plan, we talked about what's the plan? And what do you call this bond?
Say that again.
We had a flex spot, right?
Yeah,
I'm speaking about the ride share, right?
Yeah.
That's interesting for the future conditions.
Yeah.
Okay, sorry. You have it.
Yeah.
Cool. So condition 5 talks about the affordability of the project, and so this is one that I'm going to explain to you, but then I don't need to do it right on the spot. We should pose it to the applicant,
Yeah.
whether this language is acceptable, or we should tweak it to be specific to what the applicant's currently proposing. So until last meeting, we were talking about a project that was comprised of 11 units and a minimum of 25%, which needs to be rounded up. So there's 3 units of the 11, because it would be 2 and 3/4 units. 3 units of the 11 were going to be affordable. The standard in chapter 40B is 25% of the units in development have to be affordable to households earning 80% of their median income adjusted for household funds. What was presented by the applicant last meeting, the unit count was reduced from 11. That the applicant would only be providing 2 affordable units. So he was thinking, how can it be 25% of 10, still 2.5 to round up, that's 3 units. So the answer is because there's a second provision referenced in the chapter 40B regulations applied by the organizations like Max Housing that say you can reduce the percentage of 40B development to 20% affordability, provided that you also reduce the affordability of those units, make them more affordable. So instead of being affordable to households earning 80% of area median income, it's households earning 50% of it. And so it was represented by the applicant, that's what they would be doing. I had structured this condition to allow them to do it either way. It's from your perspective, if they provide the minimum percentage affordable units, so that those units count on the inventory, as do the remaining units, even though they're not affordable because of that rental and 40B law, I think it's 6 to 1 after the other. Having said that, you may feel different. You may feel that you want to be very specific about what the applicant says to do. I don't know if you have a preference. The applicant has not offered to do the discard stage to do 25% or 3 units to 80%. They've reduced it. If you want to bind them to that reduction, we can eliminate all reference to 25%. That's up to you. If you want to provide them the flexibility to later decide as they get deeper into the development process, they want to per unit as affordable, and increase the affordability to 80%, decrease the affordability, increase the sales price, or the rental value, that's up to you. But structure this condition so that it gives the applicant.
but the applicant is telling us they're gonna do the 2 and the 50%.
That is what they're currently doing.
Yeah, then I better clarify that. Having said that, I'm perfectly fine with the condition as written by council. That's legally appropriate, and it will be something that's worked out, because that's housing, about like 12 years. So I'm fine without, if it is.
So it's up to the board, the applicant's fine, you may say you're not, I said, no, the representation that's been made is 2 units at 50%. We want to say that. Check that either, that's what they're gonna do, so the decision is, we don't need to make a decision now, but we can, if you have a strong pick.
The feeling 50% is much more affordable than 80% in this stuff. All 10 are gonna count toward affordable, toward our 10%, because they're all rental.
If I may, Madam Chair,
Yep.
really quickly. I think the 50% would be favorable. That gives the master plan, offers more diversity in terms of housing options. Most, I think, taking the town would be smart, take the CBA would take it to offer 2 or 50, because you don't get that too often.
Right,
But most houses, 80%,
right,
50% is as close as you can go without building public housing.
right.
So I think having just, there's 2 units, it gives the town more diversity, and it's affordable housing stock.
Chris, you're okay? If we,
That's great, that's what I'm saying.
is that okay,
Yep, that's.
Frank?
So I'm going to amend that condition to eliminate the reference to 25.
That's, yep,
So, yeah, I'm sorry. He's on mute, I gotta keep asking.
Yeah, that's fine. So I'll eliminate the first part of the
Yeah.
condition. Condition 6 just says the final plans of the project will show the locations of the affordable units and initial lease up. Just so you know, and I think that maybe you do, maybe we've had this conversation before, I can't recall. It's a bit different with affordable rental units than it is with affordable for sale units. When you got affordable for sale units, you designate them at the outset of the project. Those remain affordable in perpetuity. Those are the affordable units. If you have 10 units, 10 homes, and you pick, number 2 and number 7, those are the affordable units. With rentals, the rentals flow. Because you may have rental units that are inhabited initially by tenant that qualifies. And then that tenant in the future, they no longer qualify. Another unit that becomes available, that can be shifted over and become it. So, the affordable units flex, and so we have this condition structured such that the actual locations upon initial lease need to be identified, that they may flow with the project.
But there always has to be 2 affordable at any given time.
That's correct. B, these are now conditions that deal with regulatory or legal components. These are far more important. The 6, we just gets over, these rather quickly, they're mostly boilerplate. I didn't have to do a whole lot of adjusting here from what we've done with the states, except eliminate the references to the ownership of that project.
Can I just interrupt for one moment? Can I ask if we can move the podium? I'm getting complaints online that they're not hearing. I'm trying just to see if we can get better audio for the
I'm getting
audience.
complaints, too. I was ignoring my phone beeper.
My kids don't want to talk to you loud, you're talking to them. Okay, so we are on condition section B, conditions essentially 7 through 15. As I was just saying, these are the legal or regulatory conditions. They're standard form. They're quite similar to what we had included in the Goodrich Brook Estates decision years ago. So condition 7 says a limited dividend organization, the applicant's profit is limited in accordance with applicable law. I won't get into all the details of that provision. It requires full certification of revenues and expenses. Again, that's all governed by the subsidizing agency. Paragraph 8 requires the regulatory agreement, which we'll reference again in a moment, to incorporate affordable housing restriction in perpetuity. The law only requires a restriction that lasts 30 years. I don't know many zoning boards of appeal that grant comprehensive permit for 30-year periods. Most of them require that the affordability restriction in perpetuity. That's historically what you've done. I believe that's what's been offered by the applicant here, so that's what the condition says. And it talks about, again, the maximum monthly rent. I'm gonna eliminate, as I did above, the reference to 80%, so there's only a reference to 50%. It's shade, I'll make that tweak. Condition 9 is something that your board has included in the years past. It's a local preference. The concept of local preference is that the maximum extent permissible by law, which is currently 70%. 70% local preference to either Lancaster residents, employees of the town, households of children attending Lancaster schools. They get a preference in qualifying for tenancies within the affordable units. It's far more complicated than it used to be, and I won't get into all the nuances. The reality of it is that it can be challenging in many communities for these local preferences to not have a disparate impact on protected classes. And so there is quite a bit of verbiage in the Chapter 40B regulations that discuss how the lottery gets conducted to avoid that disparate impact. Essentially, you have a general pool and a local preference pool. And if the diversity between those pools is not consistent, you have to actually artificially move some of the individuals from the general pool who wouldn't qualify for local preference, but that fall into protected classes into the local preference pool, so that you match that diversity in each of the pools. But be that as it may, some local preference in the eyes of most CPAs is better than none. So this condition allows you to do it to the extent the law allows you to do. Condition 10 requires the affordable units to be distributed throughout the project and not segregated from market rate units. Also requires it to be proportionally distributed among the 1, 2, and 3 bedroom units. There's obviously a bit of a disconnect here because you've got 1, 2, and 3 bedroom units, and you've only got 2 affordable units. So you can't have 1, 1, 1, 2, and 1, 3 because there's only 2 of them. So this will be determined by the subsidizing agency. I was chatting with the chair and with Brian a bit earlier and saying, I don't know what the subsidizing agency will require. They'll say 2 and 3, 1 and a 3, 1 and 2, 2 twos, and whatever combination they think is appropriate. They like to provide some diversity in housing stock, but that'll be up to them. And frankly, it's beyond your purview. You don't get to say the subsidizing agency gets to.
Can I just ask one that?
Sure.
Adam, so if they determine it to be a 3 and a 2,
Mhm.
then the 3 no longer qualifies because of their income. The other 3 is fully rented. What happens at that point? Do they have to go back to the housing and make another determination that, okay, now it has to be 2 twos? Or like, what do you do in that type of situation?
Yeah, so there's
affordable?
there's a line of communication between, you won't lose, I mean, you're never gonna lose an affordable unit. The comprehensive permit will put the entire project in compliance with zoning, it'll be out of compliance with Chapter 40B law and the subsidies that have issued under that law, so you're not gonna lose an affordable unit. But how it functions in terms of it becoming then 1, that's up to the subsidizing agency, and there's a line of communication between the agent that's conducting the lottery for these units, and the subsidizing agency. So, and it's all governed by them. There's a monitoring services agreement related to the limitation of the profitability of the project, and there's a set of services agreement that addresses the affordability.
And that's done between the owner of the project and the housing. They keep in constant communication.
The monitoring.
There's a monitoring. There's actually 2 monitoring agent for the affordability component, and then there's a monitoring agent for the dividend component of 40B. And that agent has responsibility under this. Okay, so paragraph 11 addresses the regulatory. I referred to it previously. It says prior to the issuance of any building permit for the project, the applicant shall prepare a final draft of the regulatory agreement. The regulatory agreement is simply what goes on records and goes on record and ensures the continued enforceability of 2 units within the project. And again, there's another passing reference here to the 80%. I'm going to get back and refer to 50%. Paragraph 12, we were just speaking of this, refers to the monitoring agreement pursuant to the procedures of the subsidizing agency. There's one monitoring agreement for the limited dividend requirement. There's another for the affordability requirement. Condition 13, again, we prefaced this a bit, but the discussion we just had, The applicant is required to recertify annually the project, to the project subsidizing agency, the continued eligibility of each tenant in an affordable unit, consistent with guidelines. In the event that a tenant becomes ineligible to occupy an affordable unit, the applicant may charge the tenant a market rate rent for the dwelling unit, provided, however, the applicant shall comply with requirements for converting another unit project to affordable. So again, the process I just described. 14 is just meant to capture what I spoke about a moment ago, which is the reality that the term of the regulatory system, the rules of the subsidizing agency, is 30 years. So what happens in year 31? Well, this is what paragraph 14 of condition 14 addresses. The following the expiration of the affordability restriction required by the subsidizing agency, the applicant will enter into separate regulatory and monitoring service agreements with the town to continue these commitments and purposes.
This will be the chair, James, so. you agree with that?
I will not be the chair about that.
15 says the applicant shall notify the board upon the issuance of a building permit and then subsequently upon the issuance of a certificate of occupancy for the affordable unit to help facilitate their inclusion on the subsidized housing inventory so the town can make proper application to get credit. And then we get into.
Aren't all the units gonna be notified to the town? Credited?
All the units.
Yeah. So this,
Yeah, so we can say upon the issuance of any building.
any building permit, I think, because all 10 will count toward our 10%.
Okay, so then we get into subsection C. These are whatever permit conditions that don't fall under one of the other categories that we discussed or that we will discuss. Some of these are standard form or are consistent with prior decisions you've issued. Others are a bit different. So condition 16 is one that I wasn't sure the extent to which we needed to include or the extent to which you might wish to modify. So with Goodrich Brook Estates, there were there was a waiver list that far exceeded the waiver list that's been submitted here. There were two separate components of the project that were designed very differently. Component consisting of single family homes versus sort of garden style apartments. As a consequence of that, there were some waivers that were granted, some that were denied that would have ultimately required somewhat of a redesign, especially the portion of the site that was comprised of single family. As a result of it, because we were issuing a decision on a project that was going to look different at the building permit stage than plans, even the latest plans that had been submitted to the board wanted some certainty that they were going to see these final plans with these adjustments. And so we had this condition that said prior to the issuance of the building permit, the applicant shall submit the following final plans for approval by the board, which may be distributed to its consultants for recommendations or reports, approval not to be unreasonably withheld. And then we had a list of plans that we thought were going to change. Now this project's a little different because the plans, I think, are more or less what you expect to see when this project gets constructed. Having said that, there were some plans that were not a part of the permit set. We had a permit set for Goodrich Brook Estates. I think it was 2 pages, this list that we went through with the sheets 1 through 5. I think it was sheets 1 through like 55.
Oh, yeah.
We don't have, I don't think that we have a full erosion control plan prepared here. I know we had some stormwater plans, but I don't know if we have a true erosion control plan. We didn't have something called the signage plan, although there was some signage shown. You discussed it already on the site plan, but there were no details for that. Because there were details that actually show what the signage would look like, height, construction, dimensions. So I included some of that. You can tell me the extent to which you want to keep it, you want to delete it, you can delete the paragraph 16 in its entirety if you don't think it's necessary. But I did, it is modified and is a much lesser version of what we had for Goodrich Brook Estates, but it's still a condition that you may think you don't need.
So the plans we saw tonight and the plans that we have that are September 3rd are the plans. There's gonna be no more changes. So I'm comfortable with those. Not making them go out and do another. Erosion control, Bethany, do we need an erosion control plan here?
Yeah. This is a permit list. Provided
Are you required to apply the EPA for the CGP, CG, whatever it's run? Not required.
So the applicant is indicating that this is appropriate list, what they have.
Or also, I mean, it's like,
Yeah. The signage, you saw the signage on the,
We've got it on the elevations that, the only thing I was thinking is like, if, with the adjusted if necessary. But then the A, if for some reason, if they do a build, they have to slightly modify where a sidewalk, everything's in compliance, they can't change the numbers, but if there's a layout change or anything. Making sure they come back and see that. Kind of at the end, but
And so I guess I would say that's captured by condition one. Because condition one says they have to construct in substantial conformance, and if they're going to deviate, they need to get your approval. What this was meant to capture was not even requiring them to come back formally, to seek any sort of change. Just allowing them to submit plans for you to check the box and say, this is consistent with the conditions we've imposed. But in this case, you're not imposing conditions that will require a change in the project. So what I can do, if you like, is I can delete condition 16, but since the applicant has acknowledged that there's been an erosion control plan, I can include a reference. Maybe you may not go under general, and I go under site list. Later, simply said they will provide an erosion control plan for the board's records, prior to issuance.
okay.
Condition 17, components of the project, and this isn't, you could argue this isn't a necessary condition, it seems almost obvious. It's a little less obvious with something like a subdivision that is parroting, being parroted as a 40B or, but this says the components of the project are going to remain fine. So the driveway or the drive aisle, the parking areas, lighting, landscaping, any mail shelter, building maintenance and repair, snow plowing, trash removal, stormwater management. The town's not accepting ownership in their stormwater management system. They have to plow their driveway. You would think that because it doesn't look like it's eroding, but I guess there's no harm to follow, including this in abundance of caution. So there's no question they have that responsibility. 18 says that the applicant or management company that they choose to engage will be responsible for the installation, operation, maintenance, repair, and replacement of all of these aspects of the project I just described. 19 says prior to start of construction, the applicant's registered professional engineer will prepare guidelines for the operation and maintenance of the on-site stormwater management system. They have no right? It's part of your initial submittal. So they'll fine tune that to the extent that they need to and submit a final version. But they're not.
So 18 and 19, Adam, is they're going to be the management company, like they're going to file reports with the town yearly on stormwater or on anything else that they do that's required in this permit?
So sometimes that is an express requirement of the decision. Sometimes it is incorporated into the open plan. So both. I don't know seeing it, but I be honest, I did not read it through. I don't know if the open provision that's enforced would be provided to the town in sort of a way. So if that some boards require it and boards don't require it is their obligation. If there are stormwater issues, you have the authority, you have a right to obtain a copy of the contract. In fact, the applicant is provided a copy of the contract under condition 18. Condition 19 requires this O&M plan. You have the right to enforce the decision if the stormwater is not functioning in accordance with that O&M plan because you're not performing regular maintenance. You'll see on the next page, paragraph 20, in the event that the applicant or its successors or science fails to maintain the system in accordance with the O&M plan, the town may conduct emergency maintenance and repairs, and the applicant shall permit entry for that purpose. So you have the right to do all these. Whether you want to get reports on a regular basis, again, I've got some towns that say, we get an update, or we don't want to see another report. If a problem arises, we'll hear from the neighbors, and we'll address it at that time. Other communities say, no, we want the records and it's being done. Because if we don't receive those reports, then that's a good indicator that it's not being done. You want those, I should include it explicitly.
Yeah, Bethany.
I recommend that you do require them because of course they do.
But that's what I was thinking, yeah. On a yearly basis for the life of the project or,
Feedback and at least 4 times a year. Maybe even more so.
So it's gonna be a monthly, how often should reports? Should have reports issued quarterly or biannually, or do you suggest reports be issued on each acting?
Suggest by year. Because they're not gonna be. Within some. Or if it's only gonna. Become clogged.
So, so what are we, such a report would include, I mean, when they come and vacuum, they're going to provide like a volume and any change in volume from the last time, or talk of
System status.
yeah. I guess what would the board be looking for in terms of, you know, if it's out of the balance?
These conditions seem pretty extreme for it.
We have a requirement to keep it in good working order. And maintain it.
Right.
So that's where I'm not sure we need to get for this, like. We'll hear about it if it's not being impacted, there's an issue and we can step in then, and then we'll make compliance, but I think getting.
how will you hear
Right,
about
well,
it?
that's what.
How are you gonna hear about it?
So, to go back to Brian's question, I don't think the suggestion is that they're going to be doing additional testing of the system. Works helps. The idea is that the report is simply documenting the fact that
That they
done
had
what someone
something.
can apply. So they submit every 6 months a report that says, we performed the vacuuming operations required by section A of the O&M plan on, March 30th and January or June 1st. We replaced the filter. We did this.
Right, yeah.
That's all it is, right? So, they have to do the work anyway. So the question is, do you want to require reports? And if so, how frequent do you?
Or suggest.
You think biannual? I mean, I don't see if they have to do it anyhow, why they can't just give us a copy of it. We have other projects in town where they. Or you post. And the planning board, there's conditions of some of the approvals that you're supposed to get and.
Oh, no.
Oh, no.
I'm not measure, whether a porous concrete drainage system is failing. That's how you solve it.
Yeah,
I'm sorry?
it's such.
Stop.
Yeah,
Right, okay, so you just obvious puddling and not drained.
and whoever does your report would be able to tell you. Right, we're seeing at, section, 5 and 7.
Part of the inspection and maintenance is the seeing whether there's obvious, where they should.
We don't like.
Yeah, no, I know.
The last one.
Oh, I agree.
I'm just thinking of the paperwork coming in and we can actually look at it unless there's signs, symptoms of something going on already that we're hearing about, so. I'm not saying it's a big burden, I just don't know, it's one thing where we as the town.
Well, I don't know. We don't have to say it comes to us, we can say that this report has to go to the building inspector. And to
DPW.
or DPW.
Right, but this is gonna be the same with the report that you're getting, right?
Yeah, exactly. We'll
You just get a
give a copy of the report they get.
So you can dictate where it goes. We should specify that in the condition. And my only other caveat there is communicate before you send it, right? So, I mean, it's great for the board to say, it's the DPW. DPW doesn't even know the conditions being imposed on the company. Permit gets the report.
I mean, the planning board.
And planning director can determine where it needs to go.
Yep.
Just go to it.
Yep.
Okay. 21 is a snow storage condition. We've effectively already discussed it because we jumped in earlier conversations. Snow storage has to occur in areas designated in plans and occur within parking spaces. They said there's insufficient capacity, it needs to be brought on site. This is where you get the blank because I didn't know what we wanted to do in terms of location. So again, you don't need to decide now, but this is something we need to be completed before this decision.
Do we want to impose under section 21, talk about the removal of the extra snow of the locust? We want to put like, within
Yeah.
3 days, you know, something, some sort of time frame on it?
Or does fact that it can't impede those areas.
Can't impede the line of sight of
Yeah, that pretty much covers it. They have to be moved. They can't leave it.
There's no security chasing the intersections, can be the line of sight. I think we've got that there. Right. To me, I think the foot level, because I like to keep it below the fence.
Yeah.
From a practical standpoint,
They're gonna be
I
removing
think
it.
they're gonna be removing it. I think we say that the fence, proposed fence less than 6 feet in height, so we don't actually have
No, we don't have a height of.
a height of the, have we settled on the fence height and we can lock that down?
I don't know if the applicant has, but I have a condition where I have another blank.
Yeah.
Because I saw that as well, that it says less than 6. I understand why they're saying less than 6, because once it goes 6 feet, they have to meet setback requirements.
Right.
And I actually think it shouldn't say less than 6, it should say more than 6, because 6, I don't think is subject to them. In any event, I didn't know what the minimum, presumed you don't want a 1 foot fence.
No.
So I have a blank in a future condition where you're going to specify the minimum.
I would just go 26 feet.
Me too, that's what I was thinking, so you should say for the fence.
But then you're gonna leave no storage area, it's all.
And I think a fence.
5 to 6 feet if they're gonna give, yeah, if they want our range.
I think for the neighbors, you want. Right?
Yeah, then I would limit the snow to 6 feet as well. From a practical standpoint, I'm not sure that you get there, but
I know how you can.
if they stack it and shovel it, that's fine. But
They make
keep it below 5 feet.
It's gonna be before that.
Yeah, push.
So it's 6, is there a consensus on 6 feet for purposes of condition 21?
I say 6 feet, but
Alright.
Right, that's,
Yep,
Right
6
here.
feet. 6 feet, yeah. I was at 5 or 6 feet, so 6 feet's fine.
6 feet for the fence and 6 feet for the snow store.
Yeah,
Okay. And even in the triangle,
I didn't hear that, Gene. What was that?
even in the triangle, the corner,
Yeah, 5 feet in the, yeah, that's okay.
I'm okay with that because the condition C of 21, which says repeating line of sight.
okay?
So
If business so allows it.
if you find a way to do it, that's great.
I want to know how to do it and figure it out, 'cause I gotta do it in my driveway.
you know, corner clearance in the zoning, you know, wants 2.5 feet, nothing about 2.5, or between 2.5 feet and 8 feet.
But that would be if the fence came right out to the street, and I think the
Yeah.
fence is gonna, when we get to that fence part, we're gonna stipulate it's gonna be so far back.
And I will tell you, without jumping ahead too far, next page, we go to the condition, it's condition 24 that begins at the bottom of 6, but it's the recommendations of Jeff Durr, engineer.
Yeah.
There's a reference here, and this is in the context of the site triangle and visibility. And this is why in condition 21, I'd say, except as further restricted by condition number blank. I didn't put the numbers in because these numbers are gonna change.
Yeah.
I'm referring to condition number 24, where Jeff says, snow accumulation located within these site areas that exceed 3.5 feet in height would inhibit the sight lines, which are probably be. You got that. Okay.
Okay.
Okay, so 21 is gonna be 6 feet, 22 is a condition that deals with lighting, saying lighting will comply with the zoning bylaw. I'm not gonna read 23 and 24, verbatim, but what I effectively did is I went back and I read the peer review reports prepared by Bethany for engineering and prepared by Jeff, for traffic, and of course, many of the early comments, early iterations, I guess is the result of this process, were resolved because they addressed concerns, the applicant addressed concerns that were raised. But to the extent in their final letters, they have standing issues, I tried to capture those. I guess all I can say is Bethany can review this, if she has any disagreement with how I paraphrased or rephrased what she said, she can let me know and we can tweak this. I can also send out Jeff Dirk's piece to Jeff between now and the next meeting and just ask him to confirm that I've not misstated anything.
Okay.
And then condition 25 is a standard condition saying that to the extent this project requires any other permits, from any other agency of the town, state, federal government, they have to get. So then we get to subsection D. These are site design and layout conditions. There's only a handful of them. The first one is this privacy fence that we just discussed.
Yeah.
I'll delete the language. The blank and simply say that the fence is going to be 6 feet in height.
Did we list on there, Adam, the length? Side each fence?
But sure.
Yeah, sure.
They have to construct in accordance with the plans.
Okay.
So,
Then we don't have to worry.
the plans don't show height because they're
Right, you don't
they're
have to.
three-dimensional, right? So the height needs to be specified, but they have to construct it. It does say, along the locus's southerly and easterly boundary as shown in the plans.
Okay.
So-
All right.
And then, of course, the fence has to be maintained, replaced, and repaired by the applicant. Condition 27, this is my intent, for your intentions with regard to this flat space, as we called it. So I will read this one verbatim. I've said, to address the need for temporary parking by ride shares, delivery vehicles, moving trucks, and the like, the applicant has designed the site to include a designated area for these visitors to the locus, identified on the plans as the quote, flex/loading spaces for rideshare vehicles, deliveries, and moving vehicles, unquote. Said spaces shall at all times remain unobstructed and available for use for their intended purposes, as aforesaid. Prolonged use of these spaces, for example, by a moving truck, shall be coordinated in advance by the user or resident requiring the same with the applicant and its seem to address the various components of this. I don't know how much more specific you want to get about how it gets coordinated. I think that's really for the management company to determine. It is immediately adjacent to the right of way. So if you've got your planning director or your building official or police officer driving by and seeing that with consistency, somebody's parking, it's going to
Yeah.
28 says the applicant shall relocate and replace the existing sidewalk adjacent to Center Ridge Road. This one's going to have to be tweaked because I intended to discuss this with you, but I got the answer to my questions in Mr. Pisnolo's presentation a bit earlier. I looked at some of the earlier exchanges of peer review reports or engineering and peer review responses, and there was some suggestion about the need for easements or the public having the right of access to the private property for the sidewalk. And I looked at the latest plan and I said, it looks to me like they've moved it entirely into the right of way. I couldn't tell the scale and so I couldn't, but it sounded like the entirety of it. In one spot it's immediately adjacent and then it's further spot, it's a foot or so off. It sounds like it's now entirely within the way. So I can simplify condition 28. I can also have the word concreted because we've heard it's going to be concrete and not bituminous asphalt. The applicant shall relocate and replace the existing sidewalk adjacent to the road, more or less on the entirety of the locus's frontage in the approximate location shown on the plan. Provided that said obligation shall be continued upon and subject to have provision of access to and the right to enter and complete the work within the town's right of way. I can take out in full or in part because it is entirely within the town's right of way. The foregoing replacement shall be at the applicant's sole cost and expense, and upon completion, the right shall be deemed vested in the inhabitants of the town. Again, don't really need to say that because well, I guess we do because they're actually doing the physical construction, so we're gonna own it once they're done because it's becoming town property. But everything that follows that, with respect to any portions of the sidewalk that are situated on the locus, the rest of this can get deleted because there is no portion that's gonna be within the boundaries of the property. So then there becomes a question of timing. When is this going to get done? Okay, so there was a concern with Goodrich Brook Estates, and if I think back even before that, with a couple of earlier projects you had in mid 2000s, there was a concern you had about things not getting done. Developer gets occupancy permits, disappears. Less of an issue with a rental project, but still, flips the rental project doesn't do the work. So how do we tie this to timing? So my proposal here, my language, subject to adjustment, at your request, or the applicant has a different suggestion. You obviously have to recognize that there's a possibility, although it's a known possibility, that the select board doesn't give permission for this to get done. You can't mandate it, it's up to the select board to give. So I've said, unless the applicant has diligently and in good faith pursued yet been unable to gain access to the town's right of way, completion of the sidewalk shall occur prior to the issuance of the last certificate of occupancy per unit. So that gives them the ability to do it at any time during the construction project. They don't have to have it done prior to the first year. But before they get that last certificate of occupancy, that's what you're holding as leverage. They have to have it. They can do it prior to the first CO, they can do it after the fifth CO, but they've got to do it before they get there.
Okay, that's fine with me.
Yep. Planning board uses those type of covenants.
Yeah.
Condition 29 is a holdover from your prior decision. I don't know that it's necessary. You tell me, just that there wouldn't be any above ground propane fuel storage tanks utilized in the project. I don't think any of the proposed.
I don't think you can even do fuels anymore. I don't think they allow you to boil.
I think you can do above ground propane.
You can do, today you can. Pretty much.
Okay, so then we get to subsections E and F, and these are the language is complex, but it is similar, if not verbatim, what was in your earlier decision because of what I discussed in my order, which is you've got some limited authority. So condition 30 for water and condition 33 for sewer at the bottom of the same page are very similar, at least in how they start. That the board recognizes that a comprehensive permit is a master permit, that it assumes on local permits, and that the water department is a water district. I guess it's a
Sewer district water department.
sewer district water department. Yeah, sorry for so the water department is a local board under the applicable regulations, and accordingly that authority falls to you. So that's what condition 30 says. Condition 31 says water service metering shall be as determined by the DPW. Condition 32 says that the town and its agents are authorized to enter upon the locus for the purpose of maintaining, repairing, or replacing the system of water appurtenances following its connection to the water supply. The town will be responsible for operating the system up to but not beyond the water shut off, which is typically the same condition you had previously. Subsection F in condition 33 with sewer, same language, except again, it's not a sewer department, it's a sewer district. So there's a bit more language here acknowledging that the district is still a local board. And then the key language, and it's partly in all caps on page 9, is that you're granting the approval to connect to the sewer system, but only subject to the conditions to follow and only upon the receipt of other approvals from the sewer district that are beyond your jurisdiction. And that's where 34 and 35 okay. So 34 says that your issuance of a sewer connection permit is made expressly contingent upon there being sufficient capacity. And then 35 says you have no control over that. Only the district does, and the district entered into an administrative consent order or contract with DEP, the state, and you can't modify the terms of that contract, you can't enforce that contract, apply that contract, that's up to the district. I know we had this discussion earlier on in this process, if the applicant said if there is insufficient capacity, there might not be for a couple of years, then the applicant, as I understand, in further conversation with the district that said there may be capacity, there should be capacity, and they're going to do what they need to do to bring it down. Bottom line, not your issue. So you have to give the fund up. So then we get into construction conditions. Most of these are standard. They go on for a couple of pages. I'll go through them very, very quickly. 36, comply with the ADA, State Building Code, and the AAB rules and regulations. 37, comply with blasting regulations. 38, comply with all the permits, licenses, approvals, and agreements that govern the project. 39 says there has to be a pre-construction conference that's had before construction gets underway to talk about things like access and truck routes, things of that sort that are typically of interest to your public safety officials or your DPW. 40 says that construction has to comply with local laws and as well as state and federal laws regarding noise, vibration, dust, etc. And it cites the limitations on construction activities consistent with your local bylaws. 41 says the construction site has to be secured in a manner approved by the building department. Who grants a right of access to the site to ensure compliance. 43 requires periodic inspections of the site during the construction phase, and that those be coordinated with the building department. 44 requires repair to any public way that might be caused in the course of the construction project. 45 says no CO shall be issued until the infrastructure and improvements are constructed to adequately serve that particular building or that particular unit. A condition like 45 is much more important where you have a multi-phase project or a project that is much larger in size than 10 units. So this may not be of that much concern to the applicant. I imagine that most of the infrastructure is going to be done before they even attempt to seek a certificate of occupancy for the first unit. But in the event that they do want to seek a CO early and there's some work left to be done, it refers to Chapter 41, Section 81U, which is a component of the subdivision control law that allows you to essentially obtain a form of surety to ensure that if the developer walks away without completing that infrastructure, you have the financial resources available to you to go and do it yourselves. 46 talks about determining the price or the value of any bond. 47 talks about the provision that must be included in the performance bond. And 48 is a standard condition that requires a submittal of an as-built plan no later than 1 year to the final certificate of occupancy. And figured in year was acceptable as we would have for further stage 1 year following final CO, because sometimes there are after the fact things need to be done even after that last CO issues to finish up the final course payment for it.
As for the bond, Adam, you'll help, I think Sterling Board gives us a price of what you think the value is, and make sure the language and everything is adequate.
I use, so there are forms, I think we've used them before in Lancaster, I've used them before in many of our communities, so there are forms that are typically used. It depends upon what form of surety, but the choice of the form of surety is not the board's. Many boards like to say that it's the applicant that's right in the statute. So the applicant will choose the form of surety. Sometimes it's a tripartite agreement and letter of credit, cash. On rare occasions, cash. Sometimes, often it's both. So, we'll look at the language of the form of surety issue. But in terms of determining the value of that, yes, you would typically ask the applicant to submit to you a list of what remains to be done and an estimate usually prepared by their engineer as to what the cost of each component is with a tally. And then there's a 10% margin of error that's contemplated here. Usually there's an additional contingency. Typically the contingency is more than 10%, it's 15 to 20%. You send that to the application, it says these numbers are low, they're high, they're missing items on the list. We engage in the back and forth, and once we agree on a number, that's the amount of it.
And is there one form of surety that is better? I just know planning board lately, they've had problems with
They
certain.
don't like escrows. But I think it's just how it's set up. And how if it's escrow, probably fine. I think it's just a question. I think a lot of people use
Right.
kind of agreements going on now.
Yeah, so I mean, I have personally, because I get involved sometimes back end litigating the case because we've got a cooperative developer or successor of interest that I prefer escrows and cash accounts because you have immediate access to the money. Cash accounts the best. You literally get the cash. Use it, you just reach it if the accounts will be used. I think bonds are preferred to tripartite agreements because bonding companies typically produce tripartite agreements presume that all parties, are in agreement as to what they're bound to do pursuant to the terms of that. I've had to litigate those cases before. So, but again, having said all that, it's not the applicants, it's not the board's choice.
Yeah, I know it's not our choice, but we can kind of,
If you can negotiate and get one over the other, it can be difficult to get, I mean, if you've got a project with a total development, the infrastructure, and good luck asking for a cash.
yeah, we're not gonna get.
Nobody can write your check, all that money in the check. Even the bonding costs can be expensive, so I see things like tripartites for them in those cases. With smaller projects, escrows, again, cash accounts can still be tough, but escrows are more common, bonds are.
So there's nothing in 40B that.
Right, so there's nothing in 40B that addresses performance bonds. We incorporate because there's precedent for it, 41, chapter 41, section 81U, which is subdivision control. It's kind of all that familiar with, because you don't deal with it as a zoning board. The zoning board is familiar with it. Typically, the planning director is familiar with it, as it gets dealt with often. And so to the extent you're going to incorporate 4181U, which is what I recommend you do, the precedent exists, that statute says it's the acquisition. So there's nothing in 40B that kind of fix that, or that prohibits it, or that.
So there's not, I mean, just in terms of, I don't know, your opinion, if it's just really select to go with the bond, what about bond reduction requests? Coming in periodically as the work gets done, you check off percentage of stuff is done. So town is free to grant those requests if it's a bond.
Correct. And so typically what we do is when we get the letters, when we get the form of bond, or it's presented to us or approval as the form by the board and council, we look at it and typically there's a provision that says, this bond is $1 amount, provided however that the applicant shall have the authority to seek reduction in bonds periodically through request for regular public meeting, not the public hearing.
Yeah.
And that's more common with larger projects, but doesn't happen. We have had projects where there were requests for reduction in the bond. I don't see that necessarily happening with a project of this size. Maybe. Could be. So that's the subsection. Next subsection is age, fees, and costs. Again, standard provisions. 49 it might have been a preemptive condition on my part. I sort of guessed that in every one of your decisions previously that fees aren't waived for the project or development producing the locus. 50 says invoices generated by the board consultants will be paid no later than 20 days after the decision is filed with the town clerk. I presume most of those have been paid periodically anyway, and you have extra to pay them. 51, the applicant shall pay reasonable fees to the board's consultants for post-permit reviews to the extent that they're required. Again, less of an issue with a project like this. There may be a few, but probably not to the extent that there would be with a much larger project, with plans, various iterations of future plans submitted. 52 is a standard condition saying that property taxes shall be paid in full and consistent with the provisions of Chapter 40, Section 57, which was adopted by Lancaster's town meeting. You have the ability to rescind or refuse a permit or approval for failure to pay taxes. So that's appropriate. And then the last conditions are just complete boilerplate conditions. 53 says the applicant also means that successors get signed. The board means its members from time to time, whoever they may be. 54 says tenants are bound, the project tenants are bound by the conditions of the approval. 55 says the approval gets reported with the Worcester District Registry of Deeds. 56 that the decision becomes final on the date that it is filed with the town clerk's office, or if there's an ensuing appeal on the date of final resolution of the appeal. And 57 says that the decision and approval of the project shall be null and void if construction is not commenced within 3 years of the date of the decision becoming final. It also says the applicant can seek extension if the law requires for good cause in the event that it can't commence construction.
And if they want to seek an extension, does it have to be on 6 months before the 3 years expires, or?
So I have a provision here that says it has to be done before the day the last day occurs. But there isn't anything in Chapter 40B. In fact, 40B does say that an extension request shall be deemed an insubstantial change, so it doesn't even require a public hearing, it's just a public agenda posting, correct?
But you think you'll be breaking ground before spring?
Yeah.
You know,
Close door, it's-
so those are the conditions, what's left to do for the decision, next steps. Top condition, modifying the condition based upon the discussion here tonight is complete, really the first three sections here on page one, procedural history, findings, those two sections are really sort of straightforward, it's just a history of what's occurred to date. And then section three waivers, which we've already discussed. So,
Yep.
I have enough information to go ahead and draft, those provisions for your review. Okay.
Perfect. Thank you, Adam. So I guess now what we'll do is, we'll open it to the public. It's the,
First.
yeah, you want to go inside first?
Thank you.
Sure, come on up. State your name for the record, please.
Thanks very much. Patrick Kirby from the firm Time Davis Duffy, represent Victor Solo Mellows family at 12 Neck Road. Just one initial request. It sounded like the board was going to close the public kind of portion of the proceedings
Well,
tonight.
if we close the hearing, then that means there's no more public comment. That's why we're gonna give the public the opportunity to talk, and if there's something that we need to continue to do, then we won't close the hearing.
Sure. Well, assuming that you do close it tonight, would the board allow just written comments to be submitted for another week? There seems to be some conflict between peer reviewers on stormwater. I know Ms. Ordung has expressed her opinion. We have two certified soil evaluators who have reached a different conclusion. One of whom, Dan American, was actually the first reviewer to notice this issue. He's unavailable tonight, but may be able to submit some written comments. And also, there's another, an expert, David Sperduto, who submitted a letter a couple weeks ago. I believe he's actually on Zoom tonight, and he can talk about his opinion of the groundwater level. So, but if you would allow us just to be able to submit, written comments, I think everyone would benefit from that.
Adam, once we close the hearing, we can't do anything else, so.
Not over the hearings, but
Yeah. So we would have to keep the hearing open if there was going to be more comments.
Okay, all right, well, we would ask that you do so. And just to pause on the stormwater issue, this is an environmentally sensitive area. These regulations are really important, and Ms. Ordung has expressed her opinion that the initial tested data was wrong. Not a scientist, but as I mentioned, there are a few scientists who have reached a different conclusion. And really, we're just asking that we make sure we get the groundwater level measurement correct, because if it's not, if that initial data is correct, then the stormwater system will not function. And on top of that, Mr. Sperduto might be able to comment on this further, but he pointed out that the DEP is actually planning to soon implement even more restrictive stormwater requirements, because in the changing world we live in, we have more extreme weather events. I mean, we've all seen this, and apparently the DEP considers the current restrictions will not be sufficient to protect the environment going forward. So anyway, we ask that the board consider the importance of the stormwater issue and make sure that we get it right.
Thank you. Yes, sir. Joe.
Yeah, just to respond, all due respect to the certified soil evaluators that they have. their opinions and on based on their observations of the soil. Your consulting engineer and our engineer and certified soil evaluator physically. So, has to rely on that, on your.
Thank you, Joe. Anybody else in the room wish to speak? Never much.
Good evening. I'm Alexandra Turner, Alias Turner, 620 Main Street. So some of you know, Jean, you and I have been around long enough. I know. I served as the town representative for Shaker Village, which is the lit 40B, which is meditation way up in your neck of the woods. And that was, I think that turned out to be a good project. I think most people are very happy with that. I personally agree with the goal of 40B, although I don't, I think the law is very cumbersome, but that's just a political statement of style. So I see a lot of positives with this development. It's architecturally very attractive. However, I have some issues with the scale of this project, the size of the project, not the size of the parcel. So in that vein, I'll ask some questions. And this question through the chair, maybe for council review, what is your criteria for granting waivers? My understanding was that it had to be a hardship to the land or the town. And if it's a hardship, grant them or not, what is it in this case? Because some of the waivers sound like they're easy to grant, or they'll be just nice to grant, but are they required to be granted? So that's under the scope of 40B. I also know in your analysis it has to be limited to public safety, the environment, and public health. The public health grounds will be worked out by the sewer and DPW, but in this area, we all know that we have very little or inadequate public transportation. This project literally has less parking spaces allocated than they have bathrooms. I know of a few homes with less than 2 cars. My house looks like a here, and I have two people. But so both for the comfort of the people who are living in the units and for those of us who navigate that intersection, particularly Center Bridge Neck Road, but also the abutting intersections, Main Street at Center Bridge and Neck. It's a fairly congested, difficult area. I know you have talked to public safety, but we have to use some common sense. With 18 spaces, I noticed there was so I would suggest that we really think about the number of spaces if it's possible. Council wrote on page 4 about restrictions on parking. Should include Center Bridge and Neck, and within a few hundred feet, you have Main Street, which I could see becoming that. You also have parks where I know people who have parked on if there's a social event or something like that. So I know people aren't supposed to park, but I think we can use some common sense to realize that there aren't enough parking spaces on this. And what's going to happen? I realize then the police become involved on the building inspector, but we have to permit so it's viable. I also can't imagine listening to your snow discussion. I know Eric is an expert in snow removal. I just can't imagine navigating a fire truck through that lot with the snow. My other question is, the EV spaces are reserved for EVs, so if they have one EV in the rest area and other cars parked there, or what happens if they have 3 or 4 EVs? How do you ration that out? Is it a daily number? I don't. The erosion plan. I have pictures from there. The water comes down from during a heavy rainstorm. And we're getting, as we all know, more droughts or heavy rainstorm. The water courses across the neck road center bridge and comes down. In fact, last year, the DPW, maybe, I hadn't tracked, but recently, the DPW put in a berm to protect the house on the corner of Center Bridge and Neck because they were getting flooded out, and it does. Sometimes the snowplow hits the berm, it's just a bituminous berm, and so I think that the erosion plan should probably be looked at. I know that it's maybe not technically the size of the project, but again, this is a public safety, and it ices over at that corner regularly during water. Since you discussed having the permeable pavement back in a month, I don't want it to be onerous, but I don't understand why it would be difficult to report more, monthly, when after something very simple like here it's done and it looks great. Because the problem that I found is when you extend the reporting time, by the time you realize something is wrong, and it's difficult for the management company and the people to mitigate it. By the time you have standing water, particularly if it's in the winter time, you're in trouble. I would encourage you to seek input on the water management. While they're not technically the authority, they certainly are knowledgeable. Lancaster's bylaws are strength. So finally, I would ask you to, or encourage you to leave the hearing open to the tweaks that have been done to the plan to just ratify with public safety, and that the snow removal plan is doable for them if they need to get a truck in there. How do they need it? How wide? Obviously, public safety vehicles are higher, but they also swing. So how far out and how wide? And because, as people said, if you pile it too high, it can come down. So in conclusion, there are many positives to this project. Very attractive. I personally would welcome it in the neighborhood, but on a larger parcel. I just don't, I don't know how to spell it, not Solomon. You got to be Solomon. But having 10 homes and inadequate parking spaces on a half acre, I don't think is safe. I think it's a recipe for disaster for the neighbors, people navigating those roads, and for the people that live here. So hopefully we can work something out. Thank you for your time.
Thank you, Alex.
Good evening, everyone. My name is Greg Wilson. I live at 2 Neck Road. I was wondering if the board considered where the workers will be parked during construction. With all the excavating materials, the machines, I'm sure there's going to be an office trailer there. Where are the workers going to park since there's no parking on the street? West End, how are they going to get to the job? I think it's a big consideration. And also in the handout, page 23, B. See, it wasn't read on how the wetland sign is to flag the high water line of the stream that runs near the Schmidt property. And it should be confirmed by the surveyor. It's a difficult, the board doesn't know anything.
What you were handed out was a draft of what conditions would be if this board votes to approve this project.
Right.
So 23B would be a condition that they would have to meet.
Okay. I just want to make sure the board doesn't overlook it because
No, it's something that they would have to meet.
And, you know, I wish that the board would let David Studo speak tonight. To this. David Studo.
Yeah, TV, this and when we get to the TV, they'll all be given the opportunity to speak.
Thank you very much.
You're welcome.
Martin Moore, 131 Center Road. I have just a couple of questions, you don't have to answer now, but, kind of pull your brain a little bit to, just check on them. I think at some point the DPW said something about how important the curb cuts were. Like, check on that. And the whole stormwater thing, I think, because the size of the focus is so small, to me, it doesn't make it even more critical to ensure that the stormwater management is top notch. And it's not just a remake of some catch basins that are already there. And then, once upon a time, a friend of mine, very wise, said, when you're making a decision, don't consider just the decision you're making, but consider the domino effect of your decision. And some of the dominoes that I see here, the impact of loss of a historic district, you know, my bailiwick is history and historic preservation, but it's going to, the historic district right there will be the impact of the value on the butters' homes, and most of the abutting homes, strangely enough, have all been just recently renovated to big time bucks. So it's a consideration that maybe you as individuals don't have to make, but think about, but it does impact the people that live there. Traffic congestion is another domino effect. We may not know now, but when people are all trying to get out onto Main Street or onto Centerbridge Road to get to work, it's going to start piling up cars. And if you have those stop signs, yes, the stop signs are good, but they also make people stop. And then we're going to have, like what I see when I come home via Route 90.
Seven.
What's the new word? You know what I mean? Ends up at Walmart.
Yeah. It's 117.
Yeah. 190.
Oh,
90.
Thanks.
So, yeah, that backs up all the way to Route 2 from Walmart here. So, who expected that? Nobody. So, and also, again, because the site is so small, originally there was supposed to be open space. There's no open space, none. And very tight parking, as a lot of people have mentioned. And in terms of moving the cars, there's no removal for where? The street, and then we're gonna get in the way of the plows. Stormwater management is critical, as mentioned before. Not definitely critical to the site itself, but also to the homes around there. As we know, those of us in the ALEX permanent home, we know where the water goes. It ends up in our basement. It ends up in the pools along Centerbridge and Neck. So that this is going to exacerbate that. And again, other people said it, but it is an environmentally sensitive area, and it needs to be restricted as such. And I guess I'm a little not sure about where we ended up with whether or not a safety vehicle such as a fire engine or ambulances. Ambulances is probably not so bad, but fire vehicles can get in wide enough turn wide enough so that they can easily get to where they need to be for safety reasons. And then the decision, definitely urge the board to consider, I know you've all been very careful. And it is appreciated. But the decision on this overall project will set precedent for future 40Bs, and you have to be cognizant. And another thing I think is very important to be cognizant, doesn't always happen in town, but hopefully we're beginning to get the drift. How you handle or how you negotiate with developers, say this one, the next developer that comes to town is gonna expect the same kind of treatment. And if we don't stand our ground and ensure that Lancaster's needs and safety measures and all this kind of stuff are adhered to, that just opens the door for more and more loosey-goosey stuff. So just be aware of that and keep it in mind. And thank you for her authenticity. And I would like to again say, please go over the other engineering reports. We've got 3 engineering firms that are basically agreeing, not agreeing with each one. And then there's 2, which is but the first one that I think is the developers. But they all agree. Those 3 engineering firms agree with the stormwater management issues and some of the other environmental issues. So please, review that one more time before you make your decision. And I also would like to see the board keep the hearing open so that you can do one more final review of all these little details. So we know when we move forward, it might not be what we all hoped it would be, but at least getting there. Thank you.
Thank you, Mark. Anyone?
Sam Milanes, 24 Neck Road. So I had a lot to say at the last meeting. I'm not going to repeat all of it. Sit there for all sorts of present, but I hope he gets a chance to watch it. That's good. Yeah, appreciate it. I have to do that. The one thing I did want to say that didn't do well with me is that obviously after I spoke on the town council, kind of the opportunity and solicited to respond to my comments. I felt, it somewhat painted my own comments and it wasn't intended by me, so I wasn't too appreciative of that. I don't think it's necessarily appropriate to do that. I made a statement that I felt could have stood, on its own. I think also approached the board and after the close of the meeting and made a comment about neighbors' comments that. What's that? Address the chair. Yeah, well, I'm just making a statement. Yes, I can. They addressed me at last meeting after. Again, it was unsolicited by the board, those comments, and at the end of the day, I don't think it was productive input for the community to hear that. As kind of moving on from that, I think as a layperson, I'm not a scientist either, watching this kind of back and forth about the test pits in the soil. The one thing that kind of stands out to me is the issue that, Hancock did both of the test pits, right? They did the original ones that said 5 and 6 were groundwater reserve at 3 feet. And the gentleman's name was Russell Tedford, who did the first soil evaluation, was actually in this seat for the beginning of the meetings until the issue was raised. I guess it's been back since. I think what would have been nice to kind of just clarify it would, why wasn't he around to attend the meetings again, to comment on what he observed and clarify, why what he observed wasn't right. I feel like that would have been a simple way to, actually clarify the issue from their perspective. There's been plenty of meetings, I think, to attend, since then. So, to me, that just doesn't sit well for me, even from a layperson's perspective as to what's going on with that issue. Again, it wasn't an issue that was raised by the initial peer review or Hancock themselves. It was, raised by, another third party like the. So, I think the last comment I want to reiterate is just if you do decide to
close the hearing tonight, that you think long and hard about, again, what the follow-on effect of approving something like this is for the town and the community. As Marla said, it doesn't set precedent. When you step back and look at it, you think outside of the project, you say, here we go, half acre with 10 families. And yes, they agreed to shrink it down by 1 unit and down to 2 buildings. The shrinking down to 2 buildings gave a 20 by 20 space grass for these 10 families to enjoy. Basically enough. It essentially did nothing for the project in terms of providing kind of a safe place for these families to enjoy. So we all know that it's not a safe area, for kids to play off-site, intersections and the railroads discussed. And I think the one thing I did want to comment on, I think the chairman, Mr. Chairman, at the last meeting had said, kind of in response after I spoke, that he just wanted to say that you can really only make your decisions based on what's in front of you, and I agree with that, right? It's not an easy position to be in. But I do want to remind you that, it's easy to get caught up in the measurements of this and the bylaws and all that. What's not easy to measure is, the lack of open space and the child safety for these families. That's something that, I think it's a little more subjective and, totally in your right to deny a project like this or to look for conditions that significantly reduce it. It's something that you're not going to find in the blueprint or the study's going to point out that's the issue. That's something that you would recognize in your own comments, looking at the project. And I think you total justified there. So I hope you think long and hard about that and know that you do have that approach. Thank you.
Thank you, Sam. Anyone else in the room?
Hi, I am just one of the what we choose Jennifer Coleman.
AOULIN?
Yeah.
I'm sorry, the address.
43 Metro. I've lived there for about 19 years. And I'm very, very, very concerned about so many aspects of this project, but just to narrow it down to a few tonight. The snow melts and just the rough water levels from storms and everything. I understand how this property is going to be graded, so that living right next to this unit, I'm not going to ever have to worry, or my neighbor's going to have to worry about flooding issues. I hear 10 families moving in. What are we going to have for trash removal? They're going to be dumpsters. And how are we going to be ensured that there's not going to be issues with pests and issues already? Because where that parcel of land has been neglected for at least 3 to 4 years now, while Mr. Cherubini has owned it, there's been issues with mice and other little creatures in the area because the property hasn't been mowed, hasn't been cleared, or anything. And I guess my last final problem is our DPW in the whole 18 years that I've lived in this town has been phenomenal about keeping that triangle area low and snow removal. And there's a bus stop for children there daily. I can't even imagine 6 feet of snow piling up. That needs to be addressed immediately because that's just craziness and it's a very dangerous situation.
The snow we're talking about, the 6 feet, has nothing to do with the triangle on Neck Road.
I hope not.
It has to do with the triangle within the project itself on their own private property.
That makes me very.
With a 6-foot fence here in Neck Road side and a 6-foot fence on the Centerbridge Road side, and the snow piling up inside that fence area to a height of.
And I just worry about the drainage, like if they leave that there and their new gravel or whatever they're gonna use to pave it, it's gonna melt that snow significantly faster, where is that going to drain? Making sure that that's right.
Yeah, part of the conditions would be that the snow be removed after a certain height too. And so they can store it to 6 feet while plowing. And whatever we decide, a day, 2 days, 3 days, it has to be removed off-site. Okay. And you.
Good evening. My name is Martha Schmidt, SCHMIDT, and I live on Harvard Road in Lancaster. I've lived in Lancaster since I got married in 1969. And I'm very well aware of that area. There's a lot of traffic. Sometimes you see the traffic lined up because the train is going by. And the train goes by faster now. It's 40 miles per hour. Now, you take the traffic coming down Center Bridge Road and then at a stop. You take that little bitty area, that little triangle, where there's probably people coming and going back in and out. It just doesn't make any sense to me to have, a project this big on that little acre of land, or half an acre of land. I'm worried about the children waiting for the bus stop. And I'm worried about the police department getting in there when they need to make a call. I'm worried about the fire department getting in there with their fire trucks in case there's a fire. There's so many aspects of this that just is not right. And I want the board to really consider everything before they make their final decision. Thank you.
Anyone else in the room? Okay, we're gonna go to those on Zoom. Please state your name. Looks like Duramo.
Yep, this is Joe Duramo, 127 Harvard Road. I am looking at the permit site plan that's on the town's website for Neck Farm. And I know you've gone through the waivers that are requested. The second waiver was around front yard setback, which states in that waiver section on page 1 of the plan. It says 30 feet required, 8.6 feet proposed. Well, also on page 1 of that plan, under dimensional requirements, there's a note in number 2 that says, in accordance to the town of Lancaster zoning bylaw, setbacks are measured from the street sideline or from the street center line. Center Bridge Road is shown as an arterial street on the town of Lancaster official zoning map dated 5/6/2013, amended 5/5/2014, and shall have a front yard setback of 74 feet. Neck Road is shown as a minor road in the same zoning map and shall have a front yard setback of 55 feet. So I guess I'm wondering, under the waiver request, is there a mistake in looking at the required 30 feet when in fact for Center Bridge Road it should be 74 feet as the distance that they're seeking relief for, which is a huge amount. It's a very busy street, and that 74 feet I'm sure was carefully considered before it was put into our bylaws. And why aren't we using that as the starting point for the waiver request rather than the 30 feet that's actually stated there? I'm wondering if there's someone on the board that can help me understand that.
Yep. Go ahead.
So they can maybe
So
hear
they
you
can
better.
hear you. It was
Yeah, there's
10.
two requirements. There's front yard setback of 30 feet from the right of way. And then there's a requirement of 74 feet from the center of the road. So the 8.6 is relative to 30 off the right of way. Then we have 33 feet from the center line of Center Bridge Road, which is relative to the 70. Similarly on Neck Road, we've got, it's a little hard to say where the center line is because it's triangle. It's all right of way. It's
Thank you.
Okay, so I guess I don't know how that fits with the town bylaw actually stating the 74-foot setback for Center Bridge, but the point is that this is a busy road. There's a porch on this house that's 8.6 feet off apparently the edge of Center Bridge Road, and like Martha before me talking about children, It's really a dangerous spot. Imagine a child running out that door into the street. Within seconds, they could be in traffic. The public safety commissioner for the town early on in this hearing process did express some concerns about safety, given the proximity of these buildings to a busy road. And I don't feel like it's been adequately addressed. I'm hoping the board can, take this very seriously in their considerations. Thank you.
Thank you, Joe. Is there anyone else on Zoom that wants to speak? David?
Yes,
I'd like to speak. My
Please state your name.
name is David Sperduto. I'm from Wetlands Identification, and I'm here on behalf of Greg Wilson and Marilyn Wilson of Two Neck Road. I submitted, on behalf of the Wilsons, I reviewed portions of this proposal, mainly the stormwater and soil evaluation portions. And those are the two concerns I have with it, which is the depth of groundwater and the stormwater management. And in brief, I'll give you sort of the brief version, and if the board wants me to elaborate anymore, I will. But in brief, it seems very clear to me that there are enough contradictory findings in the soil pits, observations that seem to, contradict each other, that the groundwater, the estimated seasonal high groundwater level, which is of central importance for stormwater management design, it seems that that level really cannot be concluded with any certainty, with any confidence. One of the reasons for that is that the test holes have very different kinds of soil in them. And another reason for the uncertainty is that the record presented in the submittal of the soil evaluations are pretty sketchy. I don't mean that in a bad sense. They're very typical for many submittals, but in this case, where there are questions about why we have these varying observations in the soil test holes, I think it would be, I'm very sure it would be very important to get a lot more detail. And if I can give a somewhat simple example that I hope almost anyone can understand. When you do a soil evaluation, by the way, I didn't mention, I am a certified soil evaluator, otherwise known as an approved soil evaluator, and a wetland hydrologist and a land surveyor. So when you do a test pit for a soil evaluation, you might see there's different colors of soil can be, but let's just say in one case you have some reddish brown soil. You dig down a couple feet, you see reddish brown soil. You keep digging and you start to see these little orange spots. And these spots may be what we call mottles, which are also called redox, a type of redox. So now you can say, if you kind of want to make a quick dirty job of it, which might not be correct, you can say, mottles, these red mottles, that's where the groundwater is. And it might be, but if you keep digging and below the red mottles, you just see more red-brown soil and the mottles kind of disappear, that probably is not the groundwater level. But you can still feasibly call those red mottles redox. So when we look at the results of these soil evaluations, we see these different soil layers. And at one point, the soil evaluation record says that we see redox at 31 inches, 29 inches, or whatever. And that's, in this case anyhow, with these soil evaluations, consistently where the applicant has concluded the groundwater table is, at those redox levels. But if you keep digging below some models, and the soil below that does not turn from reddish brown to a light or a dark gray, some color gray, then you may not have a water table there. There's other ways you can get models, variations in the soil texture, just ribbons of flow can do that. There's other reasons. So you kind of, for certainty or for more confidence, you need to see more than just one thing like models. And there's easily 6 or 8 different features that you can see in soil. And for example, the depth of the models, how deep the models go. And when there's a question, you really want to see at least a couple of those features to give you confidence that you're not just seeing some erratic feature in the soil, but you're actually seeing a groundwater table. So what I'm recommending is that the applicants submit soil records of the soil observations in these test holes, or unfortunately dig new test holes which show more detail. Just redox is really not, especially when there's conflicts between different test pits, it's really not a very confidence-inspiring evidence for groundwater. So that's one thing. The other thing is that I find that there are, while the stormwater report, stormwater management design has a lot of, typical and good aspects to it, it is missing some requirements of the Massachusetts Stormwater Handbook, otherwise known as Stormwater Management Standards. It's because the soils in this case at this site do not really match what the Soil Conservation Service soil survey tells us to expect, which is Paxton soils. Since the soils from the test pit data, one of the test pits, I believe, comes kind of close to a Paxton, but in all of them there's at least one feature or a lot of the soil texture itself, which does not match a Paxton soil. And when the Massachusetts Stormwater Handbook requires that when a soil does not meet the specifications or the criteria or the characteristics of the Soil Conservation Service soil survey, more analysis of soils throughout the site is required. That's about as, it might not be a really brief way to put my concerns, but that kind of covers the general gist of what I found. And if you want more details, I'd be happy to give them to you, or if you have questions.
Thank Dan Carasolo, you had your hand up. Are you no longer?
No, I don't need to say anything further.
Okay, thank you. Is there anyone else online that wants to speak?
Yeah, I don't know if you can hear me. I can't raise my hand for whatever reason. This is Lee Pothier, 66 Center Bridge Road.
Gotcha.
Yeah, I had a few questions. Number one, the snow removal. I don't want to beat a dead horse, but the thought that you can pile up 6 feet of snow against a plastic fence does not make any sense to me at all. Because I plow my own snow and I know how heavy it is, and I know how much snow you get when you plow a driveway of that size, and it's a lot. You actually need, heavier equipment than just a pickup truck with a plow for sure. But I regress. I've been here for 30 years. My basement has gotten wet every year. I pump it out. I mean, there's a lot of groundwater around here. And a lot of my concerns is that 6 feet of snow that they're going to be piling up against the fence on my property is going to melt eventually. And guess where it's going to end up? In my basement. Not cool, but also, you know, in the last couple, we moved back here like 4 years ago. We had the house on Neck Road, the old Current Topics Club. And since I've moved back here, this road is a highway. It is so fast. Yeah, we sit on the porch and we can't not believe how fast people are flying by on this road. It's not a safe road anymore. I mean, it was when we first moved in a long time ago, but Lancaster's changed a lot. You know, worry about the kids and the bus, you know, and you know, this is a great neighborhood. I've got great neighbors, you know, I just feel bad that, you know, that this precedent setting project is, you know, seems like it's going to happen. And I just hope that, you know, you really look at it and, you know, a lot of people are not going to be happy with it. And, you know, it's kind of throwing the whole neighborhood in a tizzy for sure. That's all. Thanks.
Thank you, Lee. Kendra Dickens.
Thank you very much. Kendra Dickinson, 402 Oatman Way, speaking as a private resident. As much as I may not embrace this project, given all the reasons that the abutters and the folks on Center Bridge have given, unfortunately, the 40B guidelines allow for things that aren't pretty. And I appreciate all the due diligence that Mr. Costa and the board have done to try to mitigate the circumstances that have been put before us. And trust me, I feel you. I wouldn't want that next to my house. But we're a little bit pigeonholed by the state legislature. So my ask is that those residents that truly have an issue with a 40B project speak to their state legislature and not just put it on the town, because the town's hands are tied when it comes to the ZBA on certain aspects. If you really want to institute change, go to the state legislature. Maybe use this as an example. Don't love it. Don't support it. But we have to abide by the state legislature's guidelines. Thank you.
Thank you, Kendra. Anyone else on Zoom? That's it. I don't see anything. All right. So.
Well, I don't think you'd be surprised by our position. You know, I think we sum it up in a 2-page memo that I gave to the board yesterday. I think this project has been thoroughly vetted by peer reviews from your side, for all very good experts, and we have good experts on our side. You know, there's a lot that went in for a small project. You know, people might not feel that way, but objectively, I've been involved in a lot of 40B projects where there's less material, there's less spending, you know, but we understood the high sensitivity, the sensitivity of this area, because it's an important area of things. So that's why we've been willing to work with the board, be able to accept conditions that we've accepted, change the plan as we moved on. But at this point in time, we think that we've provided all the information that we can provide, and we don't see that there's any legitimate issues that are remaining that we need to address. So we don't feel that there's any need to continue the public hearing.
Bethany, you are our engineer that has done all these aspects, and it seems like everybody seems to be concerned with aspects of soil. You witnessed these aspects, you looked at the soil, you are an expert. You feel what you've witnessed is what it is, and there isn't any discrepancy, there isn't anything that we should be concerned about.
Well, I would agree that for other computers, looking at the sets of soil data that has come from the first set of test pits in 2020 and the test pits in 2024, I can certainly understand why it looks like
Confusion.
they're confusing, they're inconsistent, and I don't want to say that first soil evaluator is wrong. I could go, but I can say that the site's very small. The test pits that we dug the second time, were very, very close to the first test. I mean, we barely 20 feet away. And we did not observe anything that was like what the first set of reviews, had documented. So I'm confident in the 2024. I do think that perk tests in that area would be something that should be done to confirm the infiltration capacity.
The perks are only done when before March, or is perks done anytime during the year?
That I would actually have to check on.
Yeah, I know perks and deep holes, one could be done at a certain time and one could be done around the year, but I don't know, I don't remember just what. Yes, Joe.
Madam Chair, as far as seasonally, there was a time we were doing the deep tests in only in the spring, so that we observed since 2008. Actually earlier than that. DEP changed to allow implement the whole plan with certified soil evaluators and training on looking at reduction more features, models, and so on. And that's when we trended away from that testing in the store. We could do the ability tests. Perk tests are standard Title V, separate perk tests are not to be used for stormwater under the handle. We can do infiltration testing. And that's not a big deal. We would welcome that as a condition of approval. And to be done prior to finalizing the plans. But I'll understand that the requirements under the stormwater management, we've met that. We've done a textual classification of the soils by the infiltration rates that the handbook allows us to do. It's Bethany makes a good suggestion in that, just as development suspenders, let's look at the actual infiltration rates through permeability tests, and then make adjustments to do that. Understand that when Bethany had talked about the fact that she didn't see median stands, that she saw sandy bones. Well, that was a difference in the textual classification of the soil, and actually had us reducing the infiltration rate that we used in the design. Went back through those calculations and sent it to the boards. So there would be that, there could be that minor adjustment to the infiltration rate that we use after we do this permeability test. It's not going to change the design. One of the aspects of infiltration is surface area. How much surface area are you trying to put water into? Sometimes we do underground infiltration chambers that have a small surface area. One of the benefits of porous pavement is it expands the surface area which you're trying to put water into the ground. So I have utmost confidence that even if there's slight deviations in the ability that the systems are going to. Just to clarify a point that was made by one of the neighbors with regards to Mr. Tedford, why he's not here. Mr. Tedford is no longer employed by Hancock. He left us on the board. taken another job months ago. Understand that I am, he's been the engineer of record for this project. I am the PE that stamped the original plans when I first came in. I am the engineer of record going forward. So I stand by the design that we've done, and as the applicant said, it's been fully vetted. The outhouse complex.
Thank you.
May I offer another comment to the board?
Hold on one second, a board member wants to speak.
Bethany, if we just step back, we've got our numbers, we think what it is. If we happen to be wrong, what's kind of the first part of the stormwater management system that'll go? If, say, it's 2 foot instead of 7. What sort of failure would we expect? And is there any way when we build this system to confirm it's actually functioning? So that instead of trying to spend a lot more time analyzing and getting more and more data, it's leave our numbers, build it, put a condition to confirm function so that we can kind of keep moving forward if we choose to move forward without having to be analyzed.
Yeah, so it is that the infiltration system has an flow basically into the town bridge. And that's where I think it's going to be most apparent that that's probably possible. You're going to know the sign, you're going to the design. But I don't think that there's any inspection boards or an inspection board that makes sense in this design and this. So I think it's really going to be an observation in terms of is this overflow continuously draining into the town system or is it relatively dry?
Understand there's 2 points. When we were first talking about where is the water tank, we were talking about whether we had a 2 foot separation. I think the disparity or the questions were it might not be 2 feet is a separation. Stand the system is coarse pavement. Built a course, which is background gravel, which provides our treatment. And then under that is a reservoir course, which is water stone, where the water sits, waiting to go into the ground. And from the bottom of that reservoir course to the water table is the 2 foot separation. So if it's 2 feet or if it's 1 foot, it was made today that if we're wrong, the system doesn't function. That's not true. If the system, if we're wrong and there's less than 2 feet, the system still functions. The system just doesn't comply with the 2 foot separation that's required by the stormwater handling, but it doesn't go to functionality. So the first thing that would be apparent if the water table was in the reservoir, which and see how that basically raised them. But it would be as definitely the same. It wouldn't have any place to go and it wouldn't overflow to the system. Moving forward, it's the pavement itself. And that's why we're done. And if we document, then it will continue to fall. If it fails, it's going to fail because it's been, areas have been entrained with silt, sediment, pollen, whatever particulates that get into the pores. It's not going to fail in entirety. It's going to go, you see sometimes where a puddle is formed and then it evaporates the remnants of the pollen or the sediment in an area. Right? And that's where the failure will happen. But that doesn't mean the system as a whole fails. There's a lot more porous pavement to go. It has to continue to get entrained and fail. The permeability rate of the pavement itself is dramatic. It can't rain fast enough and hard enough to exceed the permeability of the pavement. And the bank run gravel is also very porous, very quick. Obviously, when it gets down to the stone, that's soil beneath, that's a limiting factor. That's why we have to test it, we have to textually classify it, we have to apply the rates, and in some cases, we do permeability testing to do that. But understand that reservoir course is designed for the larger storm. We get 40 inches of rain in a year. That 40 inches of rain comes in quarter inch, half inch, and in. It doesn't come in larger storm. So this system functions every time it rains. It's not filling. It's only using a very small fraction of that reservoir. There's some factors of safety there. How the system functions to maintain harmful protection, environment protection of the neighbors. So again, we have the utmost. I have the utmost confidence standing here, right? That's hopefully better.
Well, plus, there's the fail state of the actual town's drainage system for when we have those heavy storms.
Exactly.
That is supposed to be there for.
Exactly.
So it's not, I mean, it's never gonna back up through, if it backs up that far, then we're not gonna be worried about water in the basement anyways. It's gonna be, we're floating downstream.
Wasn't there some issue from the DPW that?
Please state your name again.
Martin Moore, 131 Senator Road. And just took that interchange. Didn't the DPW say they were concerned because the current catch basin there is almost not working because it's so old, broken, et cetera, et cetera. So, and I think it was an ask to improve that catch basin.
I think they did what I think they did.
We're doing it.
Yeah, right. The updated plan is modified.
And Adam, that is in the condition that they're gonna be repairing the catch basin.
I don't think you got it done yet.
It's on the plan.
It's on the plan.
The term dividing between reciting everything that's on the plan and incorporating the plan. There were some things I did recite because they were important enough, so we talked about, signage. I didn't recite all the signage, signage showing the plan. We talked about snow storage, that's shown in the plan, but I think there are also particulars that needed to be added, so I included a whole condition. I don't think it needs to be added because it's showing the plan of the actual construction aspect of the project. If you feel differently and you want to get some language, I can get language from Mr. Gazzola or
And Adam, if the system fails, if there is a problem with the system, we have in the conditions that at that point stops because it's not meeting the conditions and they have to fix it.
They do. I mean, I get this question with great frequency during the permitting process and zoning boards. What do we do if? It's a fair question. It's a question that the neighbors has to fight for itself. If you're living next to a project and you want to know what's going to happen, that stormwater system doesn't work. What's going to happen from my backyard? What's going to happen? I've been doing this for a while. I've never given the right answer to the question. The residents, the neighbors, those who, because I don't know that there is a right answer. So we draft these conditions of approval. That's not the end, it's just the beginning. We then need, that project gets constructed, we then need to implement those conditions of approval. There needs to be monitoring of those conditions. When those reports are filed on a biannual basis, they need to be reviewed by individuals who are qualified to review them, who understand what they mean. There need to be on-site inspections periodically. There need to be responses if there are complaints, but there aren't always complaints until the serious problem arises. You have a foot of water in the basement. So there's no complete right answer to that question about enforcement. It's an active obligation of the town for this project and for every other project, comprehensive permit, special permit, variance, site plan review, every other permit you issue. I've had more instances of neighbors coming back to planning in the context of site plan review, not even chapter 48 comprehensive permits, complaining, you permitted this subdivision, now I'm getting flooding, I'm never gonna do it. And there's not always an easy answer. With comprehensive, that's because there are so decisions like the one you've got here, which is already 15 pages, and it's included in the path.
Right.
There's a lot in it. That's good and bad. Means I'm doing my job and giving you the tools to work with. That's not the end of it. You've got to then do your job. You've got to review reports, inspect the property. You say the mechanisms exist for you to be able to gain access. Provision here that gives you, there are provisions here that give you that require the existence of an O&M plan for filing those reports. If the O&M plan is not being complied with, you have a mechanism to go on the site, use that access you have a right to, and to perform whatever repairs need to be done, to go on and do the vacuuming yourself because you haven't gotten a report in a year showing that there's been vacuuming done, and you can see with the naked eye that there's puddling occurring where it shouldn't be. You can make the request. If it's ignored, you can go on, you can do the vacuuming. You can charge that to the property. So you have the tools available to you, but it does require some work.
So, I think next Thursday is the end. We have to make a decision or close the hearing by next. Isn't the deadline next week? For the public hearing. Yeah.
So the only, I looked at my records for tonight because I knew this question was going to arise. I'm sure that I was missing anything, but the last and only recent, document I have confirming an extension is this one, which was filed, on the day it cut off, but it was, and I, by turning open, extend the public hearing to September 9th. So that's done. There was, I'm not sure that it's in writing, but there was some discussion of then extending, if necessary, the deadline to take action. You have 40 days.
Right.
You're close to deliberate. Oh, you may not need more than 40 days. But there was some discussion that if you needed more time, then that could be a discussion. An effort to sort of get ahead of it, instead of drafting a decision while you're public hearing. I think your deadline.
Yes, so it's,
All right, so
and the 19th was the day we're going to be proposing the public hearing. Maybe we'll be able to make a regular decision on the 26th, but
That's not gonna
that may be enough time.
so we have to close the public hearing tonight.
You have to close the public hearing tonight unless you get a further extension.
Yeah.
That's a decision for you.
I know, I guess, no neighbors are all in arms and they don't think this is gonna work and they think it's a terrible project, but I've been on this board for a little over 30 years and I can't tell you how many 40Bs I've done and listened to neighbors complain about the same things, you know, Mill Street Extension, High Street Extension, even what we're doing Sterling Road, the one Alex mentioned up the ponds area. And the one next to the Boy Scout camp and everybody, they had kids and safety and this and that. And once they're built out and once they're done, we don't hear anything because it is smooth and it is done right. And they're gonna own it and they're gonna take pride in what they own. They're not gonna build something and walk away and, you know, let everything fall apart and let it not be nice. So I have a lot of confidence that this is gonna work out. I know people aren't gonna be happy with me, but I think we should close the hearing tonight. Let Adam continue to draft what he has to draft. You know, take into consideration, anything that we brought up this evening, and then meet in October and make an official vote on whether we approve it or deny.
Clarification,
Mm-hmm.
when you're going through the conditions. We had talked about, on condition 23, for 23.5. Having Bethany confirm for the 2A and Jeff confirm the T statement. If we close, we're not gonna be able to receive any more confirmation.
These are parts of our condition. So
Can still discuss.
this has to be done.
We can't take anything, we can't solicit information. Permitted, like what we have is here, we can deliberate on it, we can't go back to Public Works. Or we can't go back to our environmental to make sure that that claim's being paid.
It was. So to be clear through you, Madam Chair, what I was contemplating was just seeking confirmation from that I haven't botched the joint paraphrase. That would be new information. Would be then well, so we need, right? Report that back to you that if Bethany could attend your next deliberations, shouldn't she? But she could, as could Jeff. And they could answer questions about what's being said here. If it's the same information that they've already sent out, I mean, this is based upon peer reviews already submitted to you. So all I'd be doing is asking Bethany and Jeff to confirm that what I've said here is an accurate summary of the outstanding issues they had in their last peer review. And I haven't botched it in terms of my attempt to paraphrase.
Okay, I just.
Yep.
You to decide the process, we'll make sure we're
Yep, no,
getting everything.
good question. So,
Does that include in public safety also?
public safety has already given us.
Yeah, there's police, but wondering if the snow removal and the other things that
Oh,
Take a motion to close the hearing.
all right, in this hearing, there's a second,
I'll second that.
right? Okay, is there any discussion? Okay, we'll take a roll call vote, Frank,
Yes.
Dennis,
Yes.
Eric, and Jean, yes, so 4-0, we've closed the hearing. We're not gonna meet on this next week. No, gonna let Adam's not available next week.
Yes.
So Adam, you're gonna.
You're not.
Come on. So Chris.
Yeah.
Our next meeting is October 24th. Adam's not available next week. I'm not available next week. So that brings us into October. If
So we posted it every day.
that is 19, that's 7, 16, 30, 35 days from tonight.
You're still good. I mean, if you meet on the 24th and you say we're still deliberating and we can get another. I'm sure you'll be fine. It's deliberating.
Adam, do you think we need another one in there, or do you think, so you're not available the 3rd?
I'm just not available.
Okay.
Is that how open on Fridays?
To 12:30. I'm here on.
So the reason I'm asking that sort of my question is my thought always goes when you're working at close to 40-day deadlines.
Yeah.
What happens if you can't meet them? You don't have a quorum or somebody's in again. Right. So
But that's not. If it's a conflict issue, just call me and you get the extension.
Okay.
I think you've got the time anyway, because you're open Friday, because what happens is that's Thursday. So then you get to the meeting, you can't have the meeting, and Friday, you have to post for the next available date, which is 48 business hours later, so it's Friday, Monday, Tuesday is the.
Yeah, I know, that's what I'm just looking
And
at.
we'll just start with the. So 43 days.
Is that okay?
That's fine.
that all up?
If my only question is, when you board have a chance to get delivery outside?
No,
You have to come
we're gonna have to
together.
do it on the 24th. I mean,
Okay, I mean,
I wouldn't book anything else on October 24th, let's just book
yeah,
this.
or the application.
No. If we can avoid having anything else, because it's 10:30 at night,
Yeah.
you know.
No, I didn't know, okay. So everyone's gonna just need to take the evidence.
When do you think you can get something to us, so at least we can start reading and reviewing?
So knowing what we're up against, that will get it to at least a weekend. I suspect that I'll be able to do it even sooner than that. I'm actually gonna be,
If you wanna pawn some of this off. Yeah,
well, the hard part's conditions in the hard part, right? So really, in terms of the discussion that's going to occur in the 24th, I mean, I don't want to presuppose what we'll be discussing, considering or deliberating, but you've done a lot of that deliberating conditions already, and in fact, even before that, you deliberated on waivers.
Yeah.
So what you're going to see at the next meeting that you're not seeing tonight is procedural history and findings, which are fairly standard.
Yeah, complete decision.
And the waivers, but that's it. The complete decision is the rest of it's here. And you're gonna see the waivers, which, so there's not gonna be a whole lot new you haven't seen before. Having said that, I'll certainly get it to you a week in advance, so you have an opportunity to do it, and come prepared for questions, but, you know, I wouldn't anticipate, I'd be surprised if it requires more than one session to continue deliberations.
Same.
Often a comprehensive permit can be deliberated in one session after they close the public hearing, even when you haven't started the deliberation, or, and you just spent the whole meeting deliberating. So.
So, put this down for 10:24. Right? Okay. Else is not going to remember anything.
thank you.
Thank you. Correspondence. And a new application.
I just wanna mention, I mentioned earlier that there's the only thing we have in our pipeline that, proposal in the wireless, personal wireless service district, basically just replacing like equipment with like equipment. So I am looking for a.
I get confused with some of that. I'm gonna make sure that I get them with the
I thought it was up on
This is the one on Windsor Road.
Windsor Road.
Windsor Road, I just got a notice for some National Grid doing work.
Oh, I think that's constant.
Good night, Adam. Thank you.
Thanks, Adam.
Okay.
Yeah, that's constant. Yeah,
This is Windsor Road.
Okay.
Yeah, I thought you wanted that one. Are you in a butt? Oh, your farmland is butting it. Yeah. But you know what? I'm not here. So, I mean, if everyone else is here, you got enough. So
Hold on, guys, I gotta stop. Did we adjourn?
No, we did adjourn.
Hold on to the agenda. Frank, are you here next week, next Thursday?
Next Thursday?
Yeah, that's our regular meeting.
Oh, all right.
September 26th is our real meeting.
Yeah.
Yeah, all right.
All right?
That does not look like, vacation spot.
No, I think he's home.
I am home.
Oh.
Okay. All right, so Frank's here, Dennis, Rob will be back. Hopefully Mike.
If Mike is here.
We have to adjourn.
Yeah, we're still on the. Yeah, adjourn, yeah.
Everybody else? They were done. They want to go home and meet and see.
Yeah, I know.
So did you say you need to? I get a bottom notice?
I did, but.
Oh.
So his firm abuts
Oh, it's wrong.
that, and that's where he lives. It abuts
Yeah.
the towers near wall. Yeah,
Right. Just gonna have everything else.
Yeah. Yeah.
Well.
Yeah.
You know, you may have to, well, I mean, before, do you, Did I give you everything yet?
I haven't.
No, I think it's, I'll get this out to you, it's just an application, it came pretty straightforward. I've been looking for someone who's able to peer review this. I'm asking a few, the normal, the alien ones, the tie-in ones, and they don't do it. I just, I will continue to look for something, but if we don't have any comments back, by, I don't wanna give them to you on Thursday morning, we would vote on Thursday night.
But if it's a minimal thing,
Yeah.
it's nothing that's really, I think that the overlay district, the wireless, would always have town council review.
Okay,
And I'm pretty sure because of the federal FCC, whatever, whatever it is, I'm 99% sure that we always had town council.
Okay, I will do that. And, like I said, it's not a new pole, it's just using existing poles.
Just changing.
I think it's adding, it's 9 antennas.
We do it all the time.
Yeah.
Nine antennas. So I don't think, but I think we just do our due diligence, I will reach out to.
Okay. So that's all you got for next week, and then our next meeting will be the October 24th.
And we'll
Yep.
just limit that to
Yep.
any new
And I would say-
application to come in. So-
I mean, if they come in, I think we
Yeah.
have to, because we have a time frame on it. Yeah. But hopefully, like Adam said, they'll get this to us a week ahead of time. It's pretty much giving them everything we have concerns.
Procedural standpoint, when we go through and formally vote on the waivers, do those just get added into
They
that
get added
document?
into It's
So it's not a line by line, it's we vote that, we approve that document, or we don't approve that.
Yep. So if he gets it to us and we see anything we don't like and we want to change, I would say, get it to Brian as soon as you can, so he can get it to Adam. At least it's on the radar. Right?
Yes.
Yeah.
And we can't communicate together on it, but
Nope.
we can send it out.
Yes.
We can send it to Brian individually, don't CC everybody else, just, and then Brian can go to Adam. Yep. All right, we have a motion to adjourn at 10:30. I'm asking.
Oh.
You're making it.
So.
Okay, Dennis, discussion, Frank,
Yes.
Dennis,
Yeah.
Eric,
Yep.
and Judy, it's 4-0. We are adjourned at 10:30.